Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Tuesday. Happy Tuesday. Cupcakes. Why am I so small? Oh, there we go. How's everybody doing today? Today is Tuesday, June 30th, 2026. We're going to talk about Brian Tully today. Brian Tully's motion to quash and all the things. Who knows what else will happen while we're here? We've got some reading to do, so settle in. Put your earbuds in at work, and I'm going to keep you company for a while today. Sorry. Oops. Myself on 2x speed is really weird. And sorry I'm late, but you ever like when you were young, if you're Gen X like me, when you were in the car and the radio was on because it was the only thing you had to listen to besides like an 8-track player in your car, and you were listening to the radio because there were so many good radio stations back in the day, like in the 90s, in the late 80s. And you would pull into your driveway and you would wait to get out of the car because you wanted to wait for the really good song to finish. Well, that's what happened. What happened was I was listening to Dave Matthews Channel on Sirius XM, and one of my favorite Dave songs, it might be my favorite Dave song, was on, and it was a live performance from, I forget where it was from, but the name of the song is Stolen Away on 55th and 3rd, and I think that is my favorite Dave song of all time. I don't hear it a lot. He doesn't play it a lot. But I love that song so much. And if you like Dave Matthews, or even if you hate Dave Matthews, just check it out on your Spotify. Stolen Away on 55th and 3rd. I don't know. There's just something about it. It's just it's lovely. It's lovely. Oh, thank you. Thank you for the hair compliment. I discovered this new product by, I forget what it's called, Living Proof A Perfect Day spray. You literally spray it on your hair, give it a little tiny blowout or a little wrap in the air wrap. And it's like, this is 5-minute hair. I was outside watering plants this morning. I was doing outdoor maintenance, and I need my vitamin D. I need my vitamin D really badly. Seasonal affective disorder is real. And every day that I get the sun here, I'm going to be in the sun at some point. So I've done it this morning for a couple hours, and now I'm going to do it again when we're done. And it's Refresh Spray. I think that's what it's called. Yeah. I can link it to the stream if anybody's interested. They let me link products now through YouTube. So hold on, I'll link it if anybody wants it. You have to just refresh your page to get to it. So much nonsense. Good morning. Good morning, everyone. All right, let's see if I can get it right on here. It's by Living Proof. Products. Let's see. Products. What should we tag today? I'm going to, it's Living Proof Perfect Hair Day Style Refresh Mist. Starts at $18. You can get it at Ulta. I'm also going to link to this stream my favorite JLab earbuds. They last, the charge lasts forever. When I put them in, it's like battery full, and they have really cool colors, and I even have ones that like light up. Also, my favorite bronzer by Dior. Just look at the packaging of this thing. It is gorgeous. It's like a leather case that looks like it came from Chanel. And oh, I forgot my setting spray, but I'll put it on there too. And also Color Wow Dream Coat Extra Strength for Humidity is fabulous. Let me just also link a couple of the sweatshirts and other merch. I went to Cancun merch and others. Everything is still, I think, 20% off in the merch shop today. So go check it out. The trucker hats, I think, are on sale for $11.99, and the concert t-shirts. Everything's for sale in the merch shop for 20% off. I think today's the final day of that. It has nothing to do with me. It's Spreadshirt. They do it all. They print it. They send it to you. There you go. You're welcome. You're welcome. Tully said, I don't want a depo. Yeah, JLab earbuds are the only ones that I use. Well, not when I'm on stream because these are ear monitors. These are in-ear monitors, but they're the wireless earbuds. They come in really cool colors. They're like $30. Sometimes you can get them on sale for $20. And I'm not buying Apple AirPods ever. They're just too expensive. I don't like the way they look. And if I lose them, I would feel so guilty because they're so expensive. So I'm cheap. Frugal.
You're welcome.
You're welcome. So I like to share my secrets with you. So there you go. That's your secret of the day. Here's just a friendly reminder for those of you in the chat this morning. It's real easy. Be nice or leave. Be nice or leave. Not into the drama, not into the infighting, not into the BS that we see going on every single day, everywhere on nearly every channel that I want to watch. And it's not my thing. So if that's your thing, you might want to go somewhere else. Oh, you got your JLabs in lilac. I got these really cool ones that are like turquoise. You got it. I'm telling you, vague ambiguous says if I lose one more AirPod, I may lose my mind. Check these out. I don't have them in front of me right now. I have ones that are like a tan color, and I have also these cool turquoise ones that light up when they're on, which is kind of cool. And here's Nona who says, good morning, Melanie. I watch every live and I like it, but I don't comment because I'm on my son's TV while watching the kids. Love you. And wow, what a show yesterday. Can't wait for Tully today. Thank you, Nona. 0228. Your son is very lucky that he's got his mom to care for his kids while I'm assuming he and maybe his wife, if he has one, are at work. They are very, very lucky to have you watching their children because childcare is a real thing. It's a real thing. A lot of people need to pay for it. So you're an amazing Nona. And thank you. And Jessica said, what? Said, that's the exact reason I stay with my JLabs. Uh-huh. Me too. I'm frugal. All right, here we go. Today's motivational quote of the day is another one from Steve Jobs. This is Tuesday, June 30th, 2026. Steve Jobs said, oh, this is really good for all of my creatives in the chat. And I know there are so many creatives in the chat because you're all wicked smart and snarky. And in order to be snarky and funny, you have to be really smart. Okay, listen, and creative. Steve Jobs said, when you ask creative people how they did something, they feel a little guilty because they didn't really do it. They just saw something. I mean, is that great or what? Here's your motivational quote of the day. When you ask creative people how they did something, they feel a little guilty because they didn't really do it. They just saw something. So good, right? Fuck us. Fuck us. There you go. There you go. I mean, I'm so into motivation that I even wear these bracelets every single day. I wear these bracelets every single day. I love them. They're lyrics to songs or titles of songs. Let's see, on this hand. And people make these and they just give them away at the Dave Matthews events. Usually Mexico is where people like make merch and just give it out to each other. It's like a swap. They do like a trading post and people just swap merch. So let's say the yellow one here on my wrist says Gray Street. The multicolored one right here says Crash. And this is a very special one because this says, this one here, that's really kind of fading. It says, so damn lucky, Mexico 2024. And you know what's so great about that and what it reminds me of? It reminds me of the merch that we have. I went to Cancun with attorney Melanie Little because when I went to Cancun in January of 2024 to see Dave Matthews and Tim Reynolds play 3 shows on the beach, and I came back from Mexico and Alan Jackson they were doing a hearing, a pretrial 1 hearing for Karen Reed. And Alan Jackson had on a cool bracelet. It was like a rope leather bracelet. And I remember he gave an interview years later about this bracelet and where he got it. And it was like a high-end bracelet. And I said, during the hearing that we were watching, I said, oh my God, look at Alan Jackson's bracelet. That's so cool. It looks like one of the bracelets that I got in Cancun, which spiraled into a rumor by the trolls, who many of them are still on the cesspool of Twitter. The trolls saying Melanie Little was in Cancun with Alan Jackson. That is how the rumor spun out. Grant Smith Ellis, before he saw the light, when he was still on the dark side, actually chased after Alan Jackson one day with his iPhone or whatever microphone he had, as Alan Jackson was going into the courthouse, and said, did you have fun in Cancun with Melanie Little? And at the time, I don't even think Alan Jackson knew who I was, but he didn't stop there because he asked him that twice. It's on video. We've watched it before. What did I do? Just like Afro Man, I made merch.
You're welcome.
And that merch says, I went to Cancun with attorney Melanie Little, and it says, established 2024. And that's where this bracelet came from. So I keep it as a daily reminder that a hate watch is still a watch. You can make lemon pound cake out of lemons. And thank you to Grant Smith Ellis. I sent him some merch that says I went to Cancun with attorney Melanie Little. I think it was supposed to be delivered maybe yesterday or today. Hopefully he's going to have it. I sent him a hoodie, and I sent him a trucker hat because I just want him to wear it because he originated. That's where it originated. In order to see the products that are tagged to this video, you're going to need to refresh your browser. And then there should be 9 tagged products right there. Also, they are in my Amazon storefront, which is linked below this video. Okay. So there's that. Oh, and then on this hand, there's 2 other bracelets. One of them I just got at the Harry Styles concert in London. It says grape juice. I met this lovely girl from Germany who traveled all the way to London. She took a train to Paris and then a train to London to see the show. And then this blue one says so much to say, because I always have so much to say. And so does Dave Matthews. Okay. All right. Let's go to a couple of things. First. The first thing that I want to talk about today, we need to close the loop on, is Alvin Campbell Jr. And where did I just put that article? Here it is. Alvin Campbell Jr. was apparently sentenced yesterday. I don't think it was televised because the cameras were pulled out of the courtroom on Alvin Campbell. Did I say Spencer? Alvin Campbell Jr. Alvin Campbell Jr. Let's take a look. Hold on one second. Goodbye, loophole lady. If you think you're getting in here, you're not. Oh, you know what I heard this morning is that guess where Aidan Kearney, Turtleboy, is going on vacation? Like, for real. He's going on vacation to Block Island. That's hilarious. That's hilarious. Maybe he should make merch. This is, I went to Block Island with Turtleboy. And the chat was funny this morning. They were like, did Melanie send you there? It's hilarious. It's really a place. It's an island in between Montauk, New York, and Rhode Island. And you can take a ferry there from Montauk or parts of Massachusetts, or I think another place in Rhode Island. I forget where, but how funny is that? Here we go. Give him the sentence he deserved. This was in today's, I think this is the Boston Herald. And we have to close the loop on this. For those of you who don't know, they're going to tell us more about serial rapist Alvin Campbell. Was sentenced to life yesterday. Serial rapist Alvin Campbell Jr. was sentenced to life in prison yesterday after being found guilty of 21 charges, including aggravated grape and kidnapping earlier this month. No, that's not going to work. Campbell was also sentenced to serve 120 to 140 years concurrently with the life sentence. All right. Praise be to whoever this judge was. I guess we're going to find out. So he's sentenced to life plus 120 to 140 concurrently. Prosecutors said it eliminates his chance for parole. Good. He'll be locked up where he belongs for the rest of his natural life. There's a special place in hell for guys like this. Campbell, who is the older brother of State Attorney General Andrea Campbell, was on trial for assaulting 7 women while posing as a rideshare driver, picking the victims up when they were extremely intoxicated and often videotaping their sexual encounters. The jury found Campbell guilty on all counts except for a single grape charge. Judge Mary Ames, all right, shout out to Judge Mary Ames doing the Lord's work before prison justice takes over. Judge Mary Ames declared a mistrial on the count, and prosecutors said they plan to enter a motion to dismiss it. Good, they don't need to. He's going to be in jail forever where he belongs. That's where the ferry's from, Point Judith, right? The ferry to Block Island is from Point Judith, and it is a beautiful place. It's sort of like frozen in time, Block Island. Not a lot of TVs, not a lot of newspapers. I mean, when I used to go vacation there, years ago when my kids were little, it was like being in so far away. You felt like you were so far away on vacation, but it was really not far at all. It was like it's like a different world over there. It's so beautiful. Mr. Campbell, you pretended to be a safe harbor, Ames said at his sentencing. There was violence. There was violence done to each woman in the act of grape. In deciding the sentence, Ames said she considered Campbell's long and violent history, which included gun charges and assaults, as well as the evidence presented at trial and the statements of several victims. Even though the assault occurred on a single night, I have lived with the consequences every day since. The only victim to speak in person said at the hearing. After the assault, she sought a grape kit, moved out of her apartment, as she was afraid that Campbell, who knew where she lived, might come find her, and spent thousands of dollars on therapy. On the day jury selection for Campbell's trial began, the victim's wife gave birth to their first child. Arguably the most important day of my life was clouded by Alvin Campbell's accusations, she said. Looking at the judge, she said, I don't ask for the maximum sentence lightly. Then looking at Campbell sitting in a gray outfit next to his lawyers, she noted that he had not taken any responsibility for his crimes. Before that night, I had never felt unsafe, wrote another victim, who was picked up by Campbell in Fenway while she was trying to walk home from a bar. But afterwards, she wrote, I looked over my shoulder because I truly feared this man was watching me. She wrote that for years, she had night terrors and couldn't tell anyone about what happened. To this day, she still hasn't told her father. In another statement, one of the victims wrote that it was disgraceful how Campbell had tried to excuse his behavior. She called out his attorneys, who she felt mischaracterized and belittled the victims. Despite the hell of going through the trial, the victim wrote, she'd do it all over again to ensure that the defendant would remain behind bars. On our behalf, she wrote to the judge, please give him the sentence that he deserves, not the sentences that he requests. Campbell's lawyer, Andrew Kurasi, asked for an 18-year sentence to be followed by a lengthy probation period. Several people sitting in on the hearing shook their heads while he spoke. During his statement, Kurasi argued that under his recommended sentence, his client would be almost 60 years old by the time he was released from prison, and cited studies that show sex offender recidivism rates decrease with age. Oh, I'm sorry. So what? When he can't get it up anymore, maybe he'll turn to killing people instead? Great. Great argument. I mean, listen, he's a defense attorney doing his job, but still. The defense attorney also tried to argue that Campbell should be sentenced for simple grape, rather than aggravated grape because of a lack of force during the crimes, which the judge disputed. The defense lawyer also said that the early incarceration of his father, the death of his mother, and living in foster care had all shaped Campbell and led him to a life of crime. Oh, really? Did that encourage you to grape women and then film it while you were doing it? For those of you who don't know, many of these women were discovered in Campbell's phone. They didn't even know what had happened to them because they had been roofied. Right. Tell that to Fossler. Tell that to Aaron Spencer and his family. Yes, Fossler was 67. You are absolutely right, Magnolia Gypsy. Yep. Before Campbell was most recently arrested, Carusi said, He'd been trying to rebuild a life with his girlfriend who gave birth to their child after he was incarcerated. He enjoys being a father, and from what I can tell, he's a good one, Carusi said, telling the judge that his suggested sentence would give Campbell the opportunity to be a father when he got out. Wow. Wow. Well, looks like your kid's going to have to come visit you in prison where you belong, sir. Carusi finished his statement by calling the prosecution's recommendation several decades shorter than the actual sentence. I'll lock him up and throw away the key approach. Prosecutors had asked for a sentence of between 88 and 100 years, citing Campbell's criminal history, the severity of the crimes, and the need to protect the women of Boston. This was part of a criminal scheme, ADA Aaron Murphy said. It would be unrealistic to consider rehabilitation. I was also disappointed, breaking from the article for a second, to say that I really, really like Erin Murphy. And I was really disappointed that we didn't get to see her try this case. We only saw bits and pieces of her opening before they pulled the cameras out of that courtroom because there was a violation of the media order. And the victims' names were mentioned, and it was supposed to be broadcast on delay with the names bleeded out. They didn't do it. Or bleeped out. That's a bleeded. That's like a cross between yeeted and bleeped. That's not what I meant to say, but it's where it went. Aaron Murphy said it would be unrealistic to consider rehabilitation. When asked after the sentencing whether Campbell got what he deserved, Murphy responded, and then some. Aaron Murphy's a good one. Absolutely, he deserved this. His conduct warranted it, she went on. And if we're balancing his wish to be free against the safety of women in Suffolk County, we're going to prioritize the women in Suffolk County every time. Thank you, Aaron Murphy. Thank you. Can you run maybe for governor? Here's Alvin Campbell in his best gray sweatshirt coming in for his sentencing yesterday. Judge Mary Ames sentencing him to life in prison plus 120 to 140 years concurrently, which gives him zero chance of ever the possibility of parole. I really wish we could have watched it too. I don't know if the cameras stayed in, and perhaps there's some possibility of seeing this trial in the future, but this guy got everything he deserved and then some. There is a God. There is karma. Karma knows your address. Tiny Mary and Tiny Jesus are here. And ever since I found that Tiny Jesus, when last time I was in Cancun, things have turned around. You must admit. Let's look at our affirmation for a badass today, because we didn't do that yet. We have affirmations for a badass. Here they are. Yeah, he doesn't look like he has any remorse. He's got a smirk on his face. Guys like that just think they're going to get away with whatever they're doing forever and ever and ever. And remember, they knew who this guy was, like all the way back in like 2016. And they said, oh, yeah, well, there's not enough evidence that it wasn't consensual with two women that he took back to their apartment or his, I don't remember. And there's not enough evidence that it wasn't consensual, so we're not going to prosecute him. Here's your badass affirmation of the day. I am enough. I am me. I am so effing worth it. For those of you who needed to hear that today. Usually they put asterisks in here for the F word, but today they didn't. I am enough. I am me. I am so effing worth it. Yep. And so are you. So are you. If you needed to hear that today, that one's for you. Okay, let's turn to Tully. But before we do that, I just want to look one more time at this order. The order relative to the order of impoundment that Judge Gildea has ordered this emergency hearing on tomorrow at 3 p.m. in which all attorneys have been directed to appear in front of him at 3 p.m. Every single attorney who's filed a notice of appearance in this case, and I think it was something like 30 attorneys or more, have to show up. Every single one who's filed a notice of appearance on behalf of anyone. All right. And here's the first sentence. Is what has been gnawing at me. Okay. This is Judge Gildea's order dated yesterday, June 29th, 2026. If you didn't hear about it, we went over it yesterday at length. Order relative to order of impoundment, which is the endorsement on paper 112. We read it yesterday. It has to do with Proctor's medical or whatever other information he submitted to the court. Remember, They burned a whole day on this. In the morning, the judge said, go get me more information on why Proctor can't get here. And I want to know why. And then at 4:15 p.m., they came back for another hearing. And the judge said, well, you know, what this affidavit that you gave me is not the person. They're not the person, or the panel that submitted this is not qualified to opine on these things. And so he's going to have to appear for his deposition tomorrow. He didn't buy any of it. But the impounded portion was Proctor's excuse for why he couldn't be there, and whatever information was attached in that affidavit from whoever it is that could be treating him, or whatever it is. I don't know. I don't know if it's rehab for drugs. I don't know if it's sex addiction rehab. I don't know if it's marital therapy. I don't know if it's an inpatient something. I don't know if he's in witness protection. I don't know what it is, but whatever it is, this is what the judge said about it. But it was sealed, and it's not even scanned into the docket. So nobody could find this publicly unless somebody leaked it. But here it is. I have been advised of information that allows for a reasonable inference of a violation of the order of impoundment. I have been advised of information. You've been advised by who? Who advised you of that? Some crazy ass troll writing you emails? Because we've seen some of the crazy ass emails that were sent by members of the McCabe's, Alberts, and their extended family, asking for leniency for Michael Proctor, you know, things like that. Not to the court, but to other organizations. I have been advised of information by who? You've been advised of information, and then you're going to call all the attorneys in as like a spanking? They got to fly in from LA, San Diego, come in from Connecticut and everywhere to show up in front of you like a bunch of school children who are being called into the principal's office? I have grave concerns about this, okay? I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. Really? Was it one of Proctor's family members? I haven't seen any of those documents. And trust, I am sure that someone who's been reporting on this case extensively, whether me or another YouTuber or Aidan or a journalist, I am quite sure that somebody would have seen it if it was leaked, and that it would be out there on the internet like all of Aidan's total phone extraction has been. But it's just not. So I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. What the hell does that mean? Who advised you? Who's whispering in your ear? Is some wackadoo troll sending you emails? Trust me, I get a lot of really nasty, really crazy emails too. This gives me grave concerns. This first sentence gives me grave concerns because there's no evidence. I've been advised of information. Okay, who gave you information? Did Kate Peter, the not so confidential informant, send you a crazy email with some mislabeled clips from Aidan Kearney's shows? Are they trying to blame it on Aidan? But that doesn't seem to be the case because he's forcing all of the attorneys to come into court. And remember, none of these papers were filed until June 8th. That was the day of that conference. It was June 8th. Now, Aidan did do a show on June 5th. He did a show on June 5th where he said he got like an email from a source that Proctor was in Florida and that he was separated from his wife. But that couldn't have been from any court filing because the court filing wasn't even done until June 8th. And I think he said that the source said something like his wife or somebody was like friends with Courtney Proctor. Like, I don't remember exactly what he said, but it was 3 days before this filing was even made. D's nuts. Thanks for becoming a member. Erica, thank you. Chastity, thanks for giving 5 memberships. Welcome to all the new members. Gigi's back. Gigi's here. She gifted 5 memberships too. Hello to Leighton. And look at Friend of Dog gifting 10 memberships. Welcome to the 20 new members who are randomly selected by YouTube. We have special emojis for members. Check them out. You guys are amazing and kind and generous, and I love each and every one of you so much. So this in-person hearing for every single attorney is going to be tomorrow at 3 p.m. I wonder. This has nothing to do with Chris Albert sharing information with Sully. Nothing. This has nothing to do with the text messages between Buchanan and Proctor. This only has to do with, look, all you got to do is look at the title. Order relative to order of impoundment endorsement on paper number 112. Paper number 112 is Michael Proctor's personal information about why he could not come to the deposition. That's what it has to do with. And so by 4:30 p.m. today, each plaintiff and defendant, okay, so that's all of the O'Keefes involved in the lawsuit and the niece, Karen Reed, CNC Hospitality, Karen Reed, CF McCarthy's in Waterfall, someone on behalf of them, and every single attorney who has a notice of appearance in this case by 4:30 p.m. today has to file a certification under the pains and penalties of perjury. It's like, I guess, like an affidavit. And they have to swear and lay out any facts known to them as to any dissemination to anyone other than the parties in counsel in this matter of any of the contents of the material impounded by the order issued on June 8th. That was the order of impoundment. He ordered that Proctor's information that was submitted in that affidavit be sealed for 30 years. 30 years. We looked at it again yesterday. 30 years. So they have to file, I would call it an affirmation or an affidavit, saying that they didn't leak it to anybody, or they know who did. And if they know who did, it better be in there. They got to show up tomorrow at 3 p.m. Every single attorney has to show up. And here's the kicker. All further attempts to take discovery from Michael Proctor is precluded pending further orders of the court. It's been reported that Proctor asked if his deposition could start late, something like 11:30, and it had to end by 5. There were reports that he had some sort of panic attack, which is totally understandable if you're him. That's not the issue. The issue is the leak of the private information contained in that affidavit or medical report or whatever it was that the judge didn't even buy as an excuse for him not to be deposed. But now, all further attempts to continue Michael Proctor's deposition is precluded pending further orders of the court. They can't. Why is he so protected? People are asking in the chat. Why is he so protected? This reminds me so much of Lally being on the stand in a courtroom in front of Judge, it wasn't Judge Doolin, Krupp, in front of Judge Krupp. He was right in the center of Rosemary Scapicchio's barbecue on the grill. Rosemary Scapicchio grilling him about why he didn't turn over Brady material, why he didn't turn over evidence in the Miles King case for years, and what efforts he made to get that information from Michael Proctor. And then all of a sudden, Judge Krupp pulling the plug on that hearing and saying, you know what? I want you to go out and make a chart for me. You need to make a chart. You need to do a chart. Remember that? And it's never been continued. That hearing has never been continued with Adam Lally and Michael Proctor. And Michael Proctor didn't show up because he went on vacation. And then maybe he showed up another day with his big blue sunglasses and his lawyer who was yelling at Turtleboy. You remember that? Because I do. That's what this reminds me of. This is like a movie. This is like a Scorsese movie. It's wild to me. I don't know what the hell's going on, but I guess we're going to find out more. I guess we're going to find out more tomorrow. Hopefully there'll be a camera in the courtroom. Oh, here's another thing that I wanted to show you because I'm trying to figure out whether any mainstream media reported on Sean Goode. Here's the only thing I found. There may be more since then, but this is the only thing that I could find when I looked for it this morning. Take this down for a second. And if you didn't watch my show yesterday, with the explosive information that came out of Proctor's phone that Sean Goode has authored, the crazy, misogynistic, racist, anti-Semitic, I've never seen, it was more horrific to Proctor than me. To me, it was more horrific than the Proctor stuff, the Sean Goode stuff. On top, thank you for your super sticker. Hello, Falling Hero. Thank you for your deuce. No under 3 loves her J-Labs. Tara says, I work at a bakery and send home an actual cupcake with a new girl whose mom is a fellow cupcake. Sending love from Cape Cod. That's amazing. That's amazing. Send me a picture. If you know, you know. How did you know that her mother was a fellow cupcake? Oh, because she works in your bakery. Are you guys listening? Are you at the bakery right now? Make all the cupcakes. Make tie-dye cupcakes. I love that. Thank you, Tara. Leighton loves her. Gigi says Leighton is at school spitballing with her friends, so I thought I would add her as my profile picture. She's adorable. But do me a favor, Gigi, take her picture down. Don't out your granddaughter because there's people on the internet who are crazy. They're insane. And just because they like me, they may come for you. So just take it down. She's adorable. I love her. And I love you too. All right, here's WBZ reporting on the Sean Goode story yesterday. They gave it a whole 2 minutes and 12 seconds. Listen up.
Fallout from the Karen Reed investigation keeps growing. Today, the city of Canton revealed the results of an independent investigation into one of its own officers.
Hold on. Isn't Canton a town? Is Canton a city or a town? All right, I digress.
Fallout from the Karen Reed investigation keeps growing. Today, the city of Canton revealed the results of an independent investigation into one of its own officers, former Sergeant Sean Goode, including wildly offensive text messages. Here's Brandon Truitt with the story.
Well, most of the messages are so egregious we cannot read them on air. Earlier this month, we told you about a lawsuit filed by Karen Reed against the Canton and State Police Departments. This investigation has been going on in the background and confirms a lot of the material in that lawsuit. A warning, many of you will find these messages disturbing. Tonight, the town of Canton publishing the findings of a sprawling taxpayer-funded investigation into a Canton police sergeant tied to the Karen Reed case.
Who didn't even know that we had Miss Reed at the scene.
Former Sergeant Sean Goode testified in the trial, but his communications were brought to the town's attention by the district attorney's office last year during a separate investigation into fired state trooper Michael Proctor. The third-party firm combed through 200,000 text messages, photos, voice notes, and videos dating back to 2013, all while he was a Canton police officer. They found texts considered racist, sexist, homophobic, and anti-Semitic. The investigation reports Goode wrote to a friend, "I wish I had a lot of friends. I wouldn't spend money on a payday." And another one about a woman he knew. "She's the biggest. Before her maggot son died years ago, we dealt with her all the time. Can't wait to make the announcement when her other son dies. Knock, knock," with a eating grin. Ultimately, the investigation found sufficient and credible evidence that Goode violated several department policies. After publishing the findings, town leaders wrote, "We share in the clear and obvious anger of our community members. This is not simply a matter of policy, but of basic human decency. The people of Canton deserve better."
Yeah, they do. The people of Canton do deserve better. Are you going to do any more of an investigation? Are you going to investigate the people that Sean Goode was talking to? Is Kevin Albert among them? The brother of Brian Albert, on whose lawn Boston police officer John O'Keefe was found murdered. Karen Reed has been acquitted. She didn't do it. Somebody else did. Is anybody else looking into that? I know you were conflicted out of it, but that doesn't mean your people weren't talking about it. Your employees. Kelly Dever might have taken a hit from these people. Maybe she didn't want to play along, and she got her transfer to Boston PD, and then she got called down to Michael Cox's office and read the riot act about how you better do the right thing. And based on how misogynistic these text messages are, perhaps every single other officer who is employed by the police department at the town of Canton is also a misogynist. If you didn't watch the show yesterday, go back and watch it. I don't even want to repeat any of the things that he said, but I read it on the air. I didn't read the actual words, but it's on the screen. You can see it. It's horrific.
And the report was prepared to recommend Goode's termination, but he resigned earlier this month from the Canton Police Department, and just days before Karen Reed filed her lawsuit against that agency. Brandon Truitt, WBZ News.
New developments on the...
Here's one from NBC 10. I like how it popped up right at the end with my video. Okay, here you go. NBC 10 also reported on this. When was this posted? 13 hours ago. Okay, so they got on this yesterday. Good for them.
New developments on the investigation into a now former Canton police sergeant involved in the Karen Reed investigation.
A newly released report reveals text messages containing offensive language from Sean Goode. NBC 10's Colton Bradford joins us from the newsroom with the update. Colton.
Offensive? I mean, there's got to be better words than offensive. In case you're not looking at your screen, that man is a black reporter. A little bit more than offensive. Thank you, Mark McKay from the UK, for gifting a membership. I loved it so much in London. I can't wait to go back. I think I want to go to Ireland and Scotland next time, too.
From Sean Goode. NBC 10's Colton Bradford joins us from the newsroom with the update. Colton.
Yeah, horrific, Glenn. That is how the town of Canton describes the language that was used by Goode. And the report determined he violated multiple department policies through those text messages. Now, Goode was one of the officers who responded to 34 Fairview Road the morning that Karen Reed's Boston police officer boyfriend, John O'Keefe, was found lying in the snow back in 2022. He later testified in Reed's first trial in 2024. But last fall, Goode was put on leave due to a series of text messages uncovered during a separate investigation involving now former state trooper Michael Proctor. That prompted an internal affairs probe. In their report, investigators say they found that Goode sent the offensive texts, that he made discriminatory remarks, and that he conducted himself improperly. Now, before this report could be released, Goode resigned. His texts have since been included in a civil lawsuit that Karen Reed filed against Canton Police and state police. In a statement, the town of Canton says, quote, "The people of Canton deserve better. Trust isn't something we can simply earn in a written statement. It must be rebuilt through our actions, one decision at a time and one interaction at a time." That work is ongoing in the Canton Police Department.
You know what? They hired an audit company to come and do an audit. And you remember what the audit company said? They said that they thought it was ingenious. It was ingenious and innovative how the Canton PD used solo cups to collect blood evidence at the scene, and how they went and got, it was Sgt Sean Goode, who was directed by Gallagher to shoot home and shoot back and get his leaf blower out of his garage and then bring it back. And then they used the leaf blower to blow away the layers of snow to collect evidence while contaminating all of the evidence with the gas from the leaf blower. Ed Wallace's head popped off when he heard about that. Ed Wallace and Duty Ron, some of the greatest guys on YouTube. That was Sean Goode. How are you going to rebuild the trust now? Because your audit was a piece of shit too. Found nothing wrong. You're all corrupt. You're all crooked. It's outrageous. We're outraged. And we're not going to shut up about it until every single person who deserves it is in a new set of silver bracelets.
Now, the town adds that the report will be forwarded to the state's post commission. We should note here the commission has already suspended Goode's law enforcement certification.
Right. So they suspended his law enforcement certification the other day.
Ended Goode's law enforcement
Posted.
certification.
So I guess he can't. I mean, I don't know. Does that mean he can't go work somewhere else in a police department? I'm sure Colton Bradford is a very nice man, but tell me he doesn't have LC the barber cutting his hair. Remember LC, the jailhouse barber at Norfolk Superior, at the Norfolk County Pokey? I do. Okay, so that is that. I stand with Mel says, I bought the JLab earbuds and love them. I told my coworkers about them and 4 of them ordered them too. I wanted about the $500 Apple headphones and hated them. I said, stick with me, kid. Stick with me. Thanks for your 10, Mel. I'm the problem. It's me. Says, this has the Haas defendants, PD, Marcy, all over it just to shout out Karen's name, then to tarnish the elections, in my opinion. Love you, Melanie. Oh, thank you. Thank you for tuning in. From across the pond, friend of dog, get to 10 memberships. That was earlier. I thanked you already. Ginny says, worst leak ever. It isn't anywhere in all of my free Karen Read feeds. Are you also on Facebook? Is it over there? I mean, I don't know. But, the judge was advised. What does that mean? I hope the judge hasn't been duped by one of those trolls. I really do, because that's not going to look so good. Amy wants to know if Chris Maddie has to be in court tomorrow. Yes, because he has filed a notice of appearance in this case as the attorney for Colin Albert. So yes, he does. I stand with Mel says the judge is advising a reasonable inference. Mm-hmm. He doesn't even state what exactly was advised or accused about them. Does Betterow have to go? No, Betterow has not filed a notice of appearance. This is in the wrongful death case of Paul O'Keefe, Peggy O'Keefe, John O'Keefe Sr., and Kaylee, the niece, against Karen Read, the McCarthys, and Waterfall. Aidan has not been dragged into this yet, and I don't think any of his attorneys have filed a notice of appearance. So no. Thanks for your 5. Music to My Soul says, first, Judge Gildea was reading a media article related to Karen's Today Show appearance. Yep. And now he's receiving case-related information, potentially off the record. Something seems off to me. Yeah, it kind of does, doesn't it? Thanks, Gigi, for another super chat. I had this up earlier. And Invisible Woman says, Boozy is going to court tomorrow. Good. Good. I love it. Gigi says, McCabe's and Albert's stupidity is not an illness, Proctor. Thanks, Gigi. And BB said, oh my gosh, thanks for your $50 super chat, Aunt BB. You're amazing. We don't even know if they, Proctor, really received harassing phone calls, etc. Right. His attorney said that. He said, well, as soon as we filed this, all of a sudden, Proctor and his family started receiving harassing phone calls. He did say that. We also know this judge doesn't like SM either. What if this is his reason to put a gag order on the case? I hate even thinking it, much less saying it. Love you, Mel. I love you too, MPB. But I said that yesterday. I said, I wonder if we're heading towards a gag order here. But the gag order would only gag the attorneys. And the attorneys really haven't been speaking out about this case at all. Remember, there was a gag order, I think, eventually put on Karen Read and her attorneys in trial number 2. So yeah, you're right. We don't know if he received harassing phone calls, but his attorney said he had in court because maybe that's what his client told him. And attorneys tend to believe the things their clients tell them. Clients are not always truthful. Thanks for your 50. Barry Raven says, I just watched the replay of The Good Show. That was hard going. So thank you for taking us through it. I'm late today, catching up at speed. Thank you, Fairy Raven, Slancha, my little Irish cutie, patootie. Jenny Lulu says, please hit the like button. Thanks for being here for 18 months and for doing the Lord's work. Brass says on X, Proctor's house is on the market for $799K. That's interesting. It's a marital asset. I can't verify the truth or veracity of that. So thank you for telling me. MG, thank you for becoming a member. Gigi said, change the photo, Melanie. Thanks for the information. You're welcome. People are crazy, Gigi. You know that. Thanks for your 5. Got to protect yourself. Tortoise interference says, in my opinion only, of course. I don't think this judge is duped. I think he's playing along with the rest of Bev's buddies. Your 5. Jess Joe King says, Michael Proctor and Sean Goode have joined HSA, Hate Speech Anonymous. Seems that way, doesn't it? All right, let's go. Let's read Tully's motion to quash. This was filed on the 25th, so we're already 5 days behind on this. That's crazy. Well, I was on vacation. In my defense, I was in London with Harry Styles and my daughter. Okay, here you go. Highlighter at the ready. This was filed June 25th, 2026. This is the motion of non-party witness Lieutenant Brian Tully. And then it says in parentheses, retired to quash subpoena and or for a protective order. Think of quash like squash. Think of quash like squash. They want it squashed. They don't want him to have to appear at all. A motion to quash is a motion to just get rid of something. Squash it. Non-party witness, Lieutenant Brian Tully respectfully moves this court, pursuant to Massachusetts Rules of Civil Procedure 26 and 45B. Hold on. To quash the deposition subpoena and accompanying document requests served upon him by defendant Karen Reed, or in the alternative, to enter a protective order limiting the scope of examination and production. This motion rests upon two independent and compelling grounds. We'll let you know how compelling we think it is. First, the subpoena is not a legitimate exercise of discovery directed at a disinterested third party. It is directed at a retired law enforcement officer who is simultaneously a named defendant in Karen Reed's own federal civil rights lawsuit, a lawsuit in which she has asserted 7 causes of action against him arising from the identical events and subject matter that are the focus of Schedule A's 15 document request categories. Formal discovery in that federal action has not opened. Right, because you know what happened in that federal action, that the Haas defendants moved to federal court from Bristol, Superior, where it was originally filed by Karen Reed. The Haas defendants have filed an anti-SLAPP motion, and an anti-SLAPP motion stays discovery. So discovery cannot take place until there's a decision on that anti-SLAPP motion, which coincidentally is going to be heard the same day as another motion is going to be heard. I think that's, hold on for 1 second. It's a July date, and there's a hearing at 2 o'clock and then a hearing at 3 o'clock. One's in federal court. So the McCabe versus Kearney and Reed anti-SLAPP hearing is at 2 p.m. That's in front of Judge Gildea. That's the defamation case. And then at 3 p.m. on the same day, July 14th, is the Reed federal motion to dismiss filed by the House defendants. So that's going to be an interesting day. I don't know if they can be in 2 places at once, but we'll see. That's why discovery has not started. The federal court has scheduled a hearing on Lieutenant Tully's pending motion to dismiss for July 14th of 2026. Right. I just said that. See, I didn't even need to look it up. And he filed the motion to dismiss also. 6 days after the deposition commanded by this subpoena. Karen Reed may not accomplish through a third-party subpoena in this proceeding what the federal pleading standards, the pending motion to dismiss, the federal court's case management authority have not yet permitted her to do in her own case. Wrong. You're wrong. You're wrong. I'll tell you why. She filed an opposition to this. But here's the thing. If you want to be mad at anybody, be mad at the O'Keefes, because they filed a lawsuit against Karen Reed and the bars. But their lawsuit against Karen Reed is that they suffered emotional distress because Karen Reed manufactured this whole false narrative that she didn't do it and that she was framed. And part of Karen Reed proving that that narrative was not false is proving that she was indeed framed. And in order to do that, she needs discovery from Tully, and she needs to depose Tully, and she's entitled to depose Tully. So that whole argument rings hollow because it is the theory, one of the theories in the O'Keefe's lawsuit that you're filing this motion in, Tully. Second, and independently, the 15 categories of document requests in Schedule A are facially overbroad, disproportionate to any legitimate need in this wrongful death action, and impose an undue burden on a retired supervisory officer who was not a primary investigator in the underlying matter. No, but you were the boss of Tully. I mean, you were Tully. You were the boss of Proctor. You were Proctor's supervisor. You signed off on a lot of things, a lot of reports. everything, all the reports that were written, all the witness statements that were written were directed to you, to Brian Tully. Love Michael Proctor. To Brian Tully. Love Yuri Buchanan. You were the supervisor of all these mofos. Why didn't you supervise them to consider Brian Higgins a suspect when they got a hold of text messages indicating that Brian Higgins was trying to bang Karen Reed, John O'Keefe's girlfriend? Why didn't you supervise them to, maybe go inside the house? Why didn't you supervise Michael Proctor, the leading investigator, to actually go to the scene of 34 Fairview on January 29th, 2022, the day that a murdered Boston police officer was found on Brian Albert's lawn? Because according to Morrissey and others, Michael Proctor never even went to the scene that day. He went to Canton PD to do a little debrief. Then he went to the hospital to look at John O'Keefe's body, picked up some clothing off the floor, threw it all into the same bag, it was all wet and it was all in the same bag. And then he left it God knows where until it was eventually put on some butcher paper somewhere that was also left unsecured until it eventually made its way maybe into evidence weeks later. Then at 2:30, he called Dighton for backup because he was going to go tow Karen Reed's car from her parents' house without ever having seen a picture of the taillight, based on witness statements of Jennifer and Matt McCabe and Brian Albert. You were going to tow a car involved in a homicide because that's what you told Dighton when you called, because that's what they do. And then Nicholas Barrows went and met you there. And then you lied about the time you towed the car by an hour and change, because you didn't know that Karen Reed's parents had ring camera that was going to capture the real time that you took her car away. What do you say about that, Tully? And by the way, didn't somebody ask Tully for a picture of the taillight? And he was like, yeah, no, we don't have one. Or he just blew it off. Nobody ever took a picture of that taillight. Don't you think if that taillight was smashed in the driveway at Karen's parents' house, somebody would have took a picture of it? Everyone's got a phone in their pocket. He didn't. He didn't do it. So your abject failure of supervising this guy is a big problem, and it's not going to get you out of giving a deposition. For these reasons, the subpoena should be quashed in its entirety. At a minimum, a protective order is warranted, staying the deposition pending the federal court's July 14th, 2026 hearing on the motion to dismiss and the resolution thereof, and substantially narrowing the document request to categories that are relevant, proportionate, and not otherwise obtainable from the party defense. Who cares? First of all, the federal court's not going to dismiss its case against you. She's alleging civil rights violations against you. But even if by some miracle your case got dismissed in federal court, that does not absolve you of giving a deposition in the wrongful death case brought by the O'Keefes against Karen Reed. It doesn't. And in my opinion, the O'Keefes should be suing you and Proctor and Buchanan and every single person who investigated their son's murder or their brother's murder, because there was no investigation done at all, except an effort to pin it on the girl when John O'Keefe was not killed by a car. Because science, injuries, common sense, physics. Procedural and factual background. The O'Keefe civil suit and the subpoena. This action arises from the death of John O'Keefe III. Well, it's a murder, but okay. On or about January 29th, 2022. Lieutenant Tully is not a party to the Plymouth County Superior Court action. He's a retired Massachusetts State Police lieutenant who served as a supervisory officer at the Norfolk County State Police Detective Unit, SPDU. Not to be confused with SVU, because Stabler and Benson would have done a proper investigation. Where he had supervisory authority over the detective unit assigned to investigate Mr. O'Keefe's death. He was not a primary investigating officer, and he did not personally conduct interviews, execute warrants, prepare affidavits, or make charging decisions in connection with the investigation. It wasn't me. Here he comes, pulling out the Shaggy card. It wasn't me. It wasn't me. It wasn't me. But here's the thing. Didn't he draft affidavits for search warrants in the maybe in the Aidan Kearney case. Yeah, thank you. You can't make this up, says. And Stabler and Benson have never used solo cups and a leaf blower. And Tutuola, he's my favorite character. Well, really not. Stabler is my absolute favorite, but Tutuola, come on. Who doesn't love Tutuola? Pretty sure Tully drafted some search warrants that have to do with this somewhere. The false narrative. On May 5th, defendant Karen Reed caused a subpoena to be served upon Lieutenant Tully through his counsel, commanding production of documents by June 1 and his appearance for deposition on June 11. The deposition has since been adjourned by agreement to July 8th of 2026. The document request, as set forth in Schedule A to the subpoena, a true copy of which is attached here too as Exhibit B, comprise 15 categories that sweep across virtually every communication, document, recording, email, and text message touching the O'Keefe investigation. The Canton Police Department, the Boston Police Department, the Norfolk DA's office, Karen Reed herself and her representatives, the Albert family, and Lieutenant Tully's own MSP disciplinary proceedings, spanning a period in excess of 5 years. From January 1, 2021 to the present. Yeah, well, corruption runs deep. Corruption runs deep, sir. And since it has come out that you were involved in a group text message thread with not so confidential informant Kate Peter, not so special prosecutor Ken Mello, and Lindsay Gattani in an effort to set up and incarcerate Aidan Kearney, you, sir, and your phone become fair game in just about everything. Karma knows your address. Retirement's not going to save you. B, the parallel federal civil rights action and the motions to dismiss. On November 17th, 2025, Karen Reed filed a civil action in Bristol Superior Court, naming Tully as a defendant. Well, now they just call him Lieutenant Tully. Did you forget the part that he's retired? Because that was very prominent in all of the other paragraphs of your motion to quash, which was subsequently removed to the U.S. District Court for the District of Massachusetts, hereinafter the federal action. Tully promptly filed his motion to dismiss the original complaint, arguing that the complaint failed to state any plausible claim against him. Rather than oppose that motion, plaintiff filed an amended complaint on March 13th of 2026, which she is allowed to do, by the way, substantially expanding the allegations against Tully across 7 counts. Malicious prosecution under federal statute 1983, supervisory liability, conspiracy to deprive plaintiff of constitutional rights, the Massachusetts Civil Rights Act, common law malicious prosecution, intentional infliction of emotional distress, and civil conspiracy. The pattern of the amended complaint's expansion is telling. Rather than supply new facts, plaintiff principally inserted Lieutenant Tully's name into allegations previously directed at other defendants and added new upon information and belief allegations without any supporting factual foundation. Well, that's what discovery is for. She's entitled to amend her complaint. Cry about it. On April 3rd, 2026, Lieutenant Tully filed his motion to dismiss plaintiff's amended complaint pursuant to federal rules. A true copy of Lieutenant Tully's motion is attached here too as Exhibit A. As set forth in detail in Exhibit A, the amended complaint fails to state any plausible claim against Tully for the following independent reasons. 1, the complaint relies on conclusory assertions unsupported by specific facts in violation of some case law. 2, the complaint engages in impermissible group pleading that fails to distinguish Lieutenant Tully's supervisory role from the conduct of the primary investigating officers. I don't know how respondeat superior is going to play in here, but oftentimes supervisors are responsible for the people under their control and direction. and supervision and retention. Lieutenant Tully is entitled to qualified immunity on all Section 1983 claims, and for the state law claims in counts 4 through 7 are barred by the Massachusetts Tort Claims Act. Judge Casper has scheduled a hearing in the pending motions to dismiss for July 14th, 2026. Formal discovery in the federal action has not yet opened. Lieutenant Tully has not been deposed, right? Because you filed a motion which stays discovery. Has produced no documents and has answered no interrogatories in that proceeding. This subpoena was served on May 5th, 2026, 32 days after Lieutenant Tully filed his second motion to dismiss, and commands Lieutenant Tully's deposition on July 8th, 2026, 6 days before the federal court is scheduled to hear argument on whether any claims against him survive at all. I think what they forget is that Judge Gildea has a hard stop on depositions of August 17th. That's right. Scooter is here, and Scooter says, that's what I was always told as a supervisor. Something goes wrong, you better step in or it's on you. That's right. C, the federal court has already declined to authorize pre-conference third-party discovery in this litigation. The impropriety of this subpoena is further illuminated by a development in the federal action itself. Co-defendant Michael Proctor, oh, now you want to be friends? Through counsel, filed a motion in the federal action seeking leave to conduct limited pre-conference discovery directed at third parties, specifically keeper of records subpoenas to the Norfolk DA's office and the Canton Police Department in order to refresh his memory and prepare for his own deposition in this Plymouth Superior Court proceeding, which was scheduled for June 8th, 2026. Proctor argued that good cause existed for pre-conference third-party discovery because Karen Reed's counsel, who represents her in this Plymouth case, as well as in the federal action, had refused to provide him with any materials with which to prepare for that deposition. Remember that? Proctor was like, please, please, please give me my phone extraction so that I can prepare for the deposition that you want to take of me. And they were like, yeah, no, go scratch. So he filed in federal court asking the judge to force the Norfolk DA's office to give him a copy of his phone extraction. And they were like, no, we're not doing it. No, you can't have it. Federal court was like, no, I'm not doing that. Judge Casper is no fool. Judge Casper is the exact same judge who was in charge of protecting the Proctor materials and the TUI materials. Every time the Norfolk DA's office wanted to amend that protective order, they had to go to Judge Casper in federal court. She's fully familiar with the facts and circumstances of Proctor and his phone extraction. And even she said no. Oh, please. Karen Reed opposed Proctor's motion. Judge Casper denied it. Attached here too as Exhibit C. The significance of that ruling for the motion now before this court is direct. Judge Casper has determined that pre-conference third-party discovery touching the subject matter of the federal action is not appropriate, even where a federal defendant faces an imminent deposition in this parallel state court proceeding and lacks access to the materials he needs to prepare. Well, here's the thing, Tully. Proctor gave a deposition or partial deposition last week. He's already been on the hot seat once, even though now Judge Gildea because Judge Gildea has a suspicion that something was leaked, has now precluded them from taking any more discovery from Proctor. It's not going to prevent you from being deposed. Are you paying attention? Are your lawyers paying attention? Is this a union lawyer that was sent in to defend him, even though he's retired? I have questions. Having obtained that ruling by opposing Proctor's motion, Karen Reed cannot now be heard to argue that this court should compel Lieutenant Tully, a named federal defendant in her own lawsuit, to submit to a wide-ranging deposition and produce 15 categories of documents in advance of the federal court's July 14th hearing on the motions to dismiss. Yes, he can. Yes, he can. He didn't believe Proctor's bullshit. See, we have a button for that. And whatever affidavits were submitted in support of Proctor's inability to appear for a deposition, and in fact ordered him produced the next day, but Seligson and Karen Reed's team was like, sorry, we can't make it. So it was held, I think, on the 25th, which ironically is the same day your motion to quash was filed. I think that's the same day Proctor was sitting for his deposition. Remind me. Gee, Tully, did you text Proctor something that day when he was sitting for his deposition that caused him to have a panic attack? I wonder what prompted that panic attack. Was it the 25th? I think it was. The federal court has effectively signaled that discovery in this litigation in any direction awaits the Rule 16.1 and Rule 26F process. No, that's not what the federal court said at all. Stop twisting things. Stop twisting things. Karen Reed cannot invoke that ruling for her benefit in federal court while simultaneously using this court's subpoena power to do an end run around it. Tully, you were involved in framing Karen Reed, in some people's opinion, since way before Karen filed her federal lawsuit. And again, it's the O'Keefes who are alleging that Karen Reed was, spreading a false narrative, causing them emotional distress. And she's allowed to defend herself. And you are a very, very, very big part of that. Argument 1. The subpoena should be quashed or stayed because it is an improper attempt to circumvent the discovery framework of the parallel federal proceeding in which Lieutenant Tully is a named defendant. Well, Judge Gildea doesn't give a crap what's going on in federal court. He's got a schedule and he's sticking to it. Rule 45B of the Massachusetts Rules of Civil Procedure authorizes this court to quash or modify the subpoena if it is unreasonable and oppressive. Rule 26C independently empowers the court to issue a protective order for good cause shown to protect any person from, wait for it, annoyance, embarrassment, oppression, or undue burden or expense. Well, ask your buddy Michael Proctor how that argument worked out for him in front of Judge Doolin when Proctor's attorneys went in and said, Your Honor, hasn't Michael Proctor been through enough? This is going to cause him great embarrassment if these text messages are released. And Rosemary Scapiccio, one of our queens, got up and started screaming, why are we protecting him? Why is anybody protecting Michael Proctor? And Judge Doolin didn't buy it either. And those text messages were allowed to be released in Karen Reed's lawsuit. So there you go. We don't care about your embarrassment or annoyance. What we care about is corruption and the wrongful persecution twice of a woman by the name of Karen Reed, who could be any one of us, for murder. For murder. She was tried for murder for a car accident that didn't even happen. You think we care about your annoyance or embarrassment? You got to retire. Probably keep your pension, Tully. I don't even know how old Tully is. Anybody have any idea how old Tully is? I think he's a lot younger than he looks, but I'm not sure. Together, these provisions confer broad discretionary authority to regulate subpoenas that are directed at non-party witnesses for improper purposes. Yeah. Well, it may have worked in federal court with Judge Cannoni, not giving Karen Reed access to Brian Higgins' phone, Brian Albert's phone. Then they destroyed their phones. Not giving Karen Reed access to a lot of other Rule 17 motions that she made. One of them involving Jennifer McCabe's Google searches went all the way up to the SJC before that was reversed. But I don't think it's going to work in civil court, because in civil court, the rules of discovery are much more lax and much more free. The subpoena here is not directed at a disinterested third party. Lieutenant Tully is simultaneously a named defendant in Karen Reed's own federal civil rights lawsuit, in which she has sued him personally on 7 causes of action arising from his role as a supervisory officer in the O'Keefe investigation, the same investigation that is the subject of this wrongful death action. and the same subject matter that is the focus of every one of Schedule A's 15 document request. Right. And that's exactly why it's relevant. Thank you for proving my point. The overlap between the federal action allegations and the Schedule A categories is complete and unmistakable. Exactly. A third-party subpoena cannot be used to circumvent federal discovery limitations. Courts have consistently recognized their inherent authority to stay or quash subpoenas where the practical effect is to circumvent the discovery framework of a parallel proceeding. Citing some cases. The rationale is straightforward. If discovery is not yet opened in the primary proceeding in which the witness is a named defendant, permitting the adverse party to obtain functionally identical discovery through third-party subpoena in a related case frustrates the orderly management of litigation and deprives the defendant of the protections afforded during the pre-discovery phase of the primary case. Listen, it didn't work for Proctor, and it's not going to work for you. Okay? Proctor sat for part of his deposition. What makes you different from Proctor? You were his supervisor. Those protections include, critically, the threshold determination by the federal court of whether the complaint against Tully states any plausible claim at all. Doesn't matter. It doesn't matter. It's not the same case. They're two different cases. Even, like I said, even if, which is wildly a stretch, your case is dismissed, it doesn't matter. You're still a witness in this case brought by the O'Keefes, by the way. And then he goes on to to wildly argue the determination is now imminent. Judge Casper has scheduled a hearing of the motion to dismiss for July 14th. If the federal action is dismissed following that hearing, as Lieutenant Tully's briefing argues, it should be on multiple independent grounds. A deposition conducted on July 8th will have served no legitimate purpose in this wrongful death action. Yes, it has absolutely a legitimate purpose. This argument is laughable. While imposing upon Lieutenant Tully the full burden of federal defendant discovery through the back door of a state court subpoena on the eve of a federal hearing. No. First of all, the judge is not going to rule you think the judge is going to rule on the bench, from the bench on July 14th? No, she's not. She's going to take it under advisement. She's going to take her time. She's going to have her interns and clerks researching it. She's going to issue a written decision, and it could take 90 days for a decision. Who knows how long it would take to get a decision? So no. What part of Judge Gildea's order, we have a hard stop on discovery August 17th, do you not understand? B, the July 8th deposition date and the July 14th federal hearing date make a stay particularly compelling. I don't think Judge Gildea is going to buy this. The temporal relationship between the commanded deposition date and the scheduled federal hearing date is striking and dispositive on the question of state. No, because you told us you were originally subpoenaed for a deposition in April, and then by agreement, it was adjourned until July. Okay? I just want to confirm that before I run with it. Okay, sorry. May 5th. May 5th was when she originally served the subpoena on him. She wanted documents by June 1 and him to appear for deposition on June 11. So he's been on notice of this since May. And then they agreed to adjourn it to July 8th. And then he made this motion. So the timing of July 8th is not suspicious because the original date was June 11th. Okay. Anybody with any sort of logic and context clue ability and ability to read and understand and comprehend and has common sense understands that. Karen Reed subpoena commands Lieutenant Tully to appear for a deposition on July 8th of 2026. Well, the first date was June 11th. Stop it. Judge Casper has scheduled oral argument on the motion to dismiss, including Lieutenant Tully's for July 14th. Lieutenant Tully is thus being commanded to submit to a wide-ranging deposition. As a federal defendant, 6 days before the court overseeing his federal case hears argument on whether he belongs in that case at all. It doesn't matter. It doesn't matter. No legitimate discovery purpose in this wrongful death act. I mean, they keep repeating themselves, and I'm going to just keep repeating myself. The O'Keefe plaintiffs, who are the parties to this action, have not sought this deposition. Of course they haven't. Of course they haven't. They still think John O'Keefe was hit by a car. And that Karen Reed's narrative that she was framed by you and Proctor and others is true. In order to defend herself, Karen Reed has to prove that it's not true. That he was hit by a car and that indeed she was framed. So of course they don't want your deposition. It is Karen Reed's subpoena served by the defendant in this case against a non-party who's her own federal defendant. Yeah, Tully is hers. At least you understand that. Karen Reed is going to own you, by the way, Tully. She's going to own you. She's going to own the state of Massachusetts. They might as well just call it Karen Reed Massachusetts when this is all over, because she's going to own every single one of you mofos. It's a stress ball. That's what I'm throwing around, a stress ball. Hear that again for emphasis. Who is her own federal defendant. She's going to own it all. She's going to own it all. How big of a check? Here, let me ask you this. Let me ask you this, chat. You're wicked smart. You're all wicked smart. How big of a check would somebody have to write you in order for you to go through everything that Karen Reed has gone through at the hands of Canton PD, the Massachusetts State Police, Tully, Proctor, Buchanan, Nicole Albert, Brian Albert, Jennifer McCabe, Matt McCabe, and Brian Higgins? How much would somebody have to pay you to go through everything that she's had to go through from January 29th, 2022 until today and continuing for the rest of her life? How big would that check have to be in order for you to have to go through that? Think about that number. Think about if there is a number. And then tell me what that number is. 227 million. This is Norfolk tyranny. Other people saying that number does not exist. 227 billion. How do you think a jury's gonna come to that determination? Karen Reed lost everything. Everything. Her reputation, her jobs, her 401ks, her home, her dignity when she was dehumanized by Proctor and those text messages and the body cam footage of her being arrested at her back door and the things that the things that Proctor said about her and the things that Goode said about her, and this stuff is still coming out. It's still coming out. She had to go through 2 trials, the stress and the exacerbation of all the medical conditions that she already had. She's over $5 million in debt to her attorneys, many of whom worked for free. How much would somebody have to pay you? How about 227 billion? It is Karen Reed's subpoena served by the defendant in this case against a non-party witness who is her own federal defendant, timed to extract this testimony from Lieutenant Tully immediately before the federal court rules on whether her claims against him are legally viable. A brief stay of fewer than 2 weeks would cost the parties nothing. Well, the federal court's not going to rule on it on your timeline or on Judge Gildea's timeline. Take them all down. Take them all down, says Veronica. A brief stay of fewer than 2 weeks would cost the parties nothing, while allowing the federal court's threshold ruling to inform whether and on what terms Lieutenant Tully's deposition in this proceeding is appropriate at all. Have you read the complaint, sir? Have you read the complaint? Are you enjoying your retirement? Are you? The chronology, okay, see, the chronology of this litigation confirms the improper purpose of the subpoena. No, Tully, you knew. You've known since day one they were going to want your deposition. Don't be stupid. Are you the Fredo of the Massachusetts State Police Department? Come on. The sequence of events in this litigation tells a clear story. Lieutenant Tully filed his initial motion to dismiss the original complaint in the federal action, identifying the factual and legal deficiencies in the claims against him. Rather than oppose that motion, Karen Reed filed an amended complaint on March 13th, 2026, attempting to cure those deficiencies. But doing so, as Exhibit A demonstrates, primarily by inserting Lieutenant Tully's name into existing allegations and appending upon information and belief assertions without factual support. Lieutenant Tully filed his motion to dismiss the amended complaint on April 3rd, 2026, again identifying with particularity the absence of specific non-conclusory factual allegations against him. This subpoena was served 32 days later. The federal motion to dismiss hearing is now scheduled for July 14th. The commanded deposition date is July 8th. Boy, I hope Tully has a free attorney paid for by the union, because this is an expensive piece of paper. This is an expensive pleading. The 15 document categories in Schedule A track the factual gaps in the amended complaint with precision. I wish I could say more about your investigation into the murder of John O'Keefe. That it was precise, or that there was any precision at all. You're such a good supervisor, Tully. Request 5 seeks documents concerning the individuals at 34 Fairview Road, the same individuals whose investigation the amended complaint alleges Lieutenant Tully failed to pursue. That's right. Damn right. Request 11 seeks communications with the Norfolk DA's office, directly tracking the amended complaint's allegations concerning coordination between MSP and the Norfolk DA's office. That's right. Because that's her defense in this case too. What part of that don't you understand? Request 12 seeks all documents concerning Michael Proctor, the subordinate officer. Oh, at least we know that, at least you're admitting that he's your subordinate, whose conduct underlies the supervisory liability count. Request 13 seeks Lieutenant Tully's own disciplinary records, expressly referenced in the amended complaint at paragraph 140. Okay, good. Everything's related, sir. Schedule A is not a discovery instrument designed to develop evidence for this wrongful death action. Again, I hate to keep repeating myself. It's a vehicle for building the factual record that the amended complaint failed to plead and that federal pleading standards require it to contain, extracted from Lieutenant Tully on the eve of the federal hearing at which those pleading failures will be argued. Listen, Tully, they've already got Proctor's total phone extraction. If you think that they don't have anything on you from Michael Proctor's phone, I'm willing to bet $227 million that you would be wrong, sir. So part of this exercise in discovery is to see if you turn over the stuff that they already have, or if you're going to withhold it. Maybe you destroyed your phone too. Did you learn from Higgins how to crack a SIM card in half? Was that something new to you? Did you learn from Michael Proctor that even if you set your iPhone to auto delete everything after 30 days, it doesn't really work that way with the cloud? Are you scared? The court should not permit its process to be used in this manner. The appropriate remedy is to quash the subpoena in its entirety. At a minimum, a stay pending the July 14th federal hearing and its resolution is compelled by the circumstances. No, it's not, because it doesn't matter if your case is thrown out or not. You're still a precipient witness in this case. The document requests in Schedule A are facially overbroad, disproportionate to the needs of this action, and impose undue burden on a non-party witness. So here he says they're oppressive, they're too broad, unduly burdensome. The standard for evaluating burden on non-party witnesses is deliberately more protective than the standard applied to parties. Schedule A's 15 categories demand without meaningful limitation every document, communication, email, text message, audio recording, or video recording in Lieutenant Tully's possession touching the following subjects. 1. Karen Reed or family members, agents, attorneys, and representatives without any subject matter or temporal limitation beyond January 1, 2021. Remember, wait, I got it. Remember when, remind me also what court proceeding this was in? Remember when the Commonwealth demanded and received Bill Reed's bank records and Nathan Reed's bank records in a proceeding? And I don't remember which proceeding, if it had to do with Karen Reed or if it had to do with Aidan Kearney, but they actually got subpoenas and obtained Bill Reed's banking records, right? And Nathan Reed's banking records to see if they had made any payments to buy Aidan a Lexus or something, some bullshit like that. Do you remember that? Who filled out those search warrants? Right? That was crazy, right? Remind me what proceeding that was in. It was pre-trial, right? It was pre-trial. It was pre-trial 1. Thanks, Lori. Martinez reminded me, yeah, they were looking to see if the Reeds bought Aidan a Lexus. Yep. And I think that was even before trial number 1. Like, they are grasping at straws, and I like to say wet paper straws because there's nothing I hate more than a paper straw. Yeah, they wanted to see if they bought Aidan a car. They thought the Reeds gave Aidan a car. Like, who signed off? Did Tully sign off on that search warrant? And was there communications about it? Because, yeah, all that stuff would be relevant because they really wanted to shut everybody up. So I'm wondering if Tully's the one who signed off on those search warrants. I don't know, just spitballing with you, something to think about. They were trying to find another reason to incarcerate Aidan Kearney, and they did that by getting the bank records of Bill Reed and Nathan Reed, which is outrageous. In fact, one of the only depositions that Diller has done so far is a woman named Caitlin. I think her name is Caitlin, who is either the wife of Nathan Reed or the ex-wife of Nathan Reed. Like, what do they need her deposition for? How is this woman Caitlin's deposition going to prove that John O'Keefe was hit by a car? This is the kind of discovery that Mark Diller is doing in this case. You don't think that's a little bit strange? Why is he not deposing, I don't know, the medical examiner? He's got to prove, thank you, Olivia Nile, is saying that, yes, we love you, Olivia. Oh, yes, we do. Tully signed off on the search warrants. See how this is all coming together now? See what they're trying to hide? See why Tully doesn't want anybody deposing him or touching his stuff? Have we ever seen those search warrants, Olivia? Hopefully this has given you some material to post about today. Olivia's back, says the search warrants were for Turtleboy's bank records and financial statements from Nathan and Bill Reed, based off of a word of Lindsay Gattani, I believe. Right, that that they bought Aidan a Lexus or something such as like that. Tully was on everything. Tully was on everything. Mary, you're right. Tully signed off on the warrants, but who swore them out to the judge, says Scott. Oh, and this is interesting. So Lupo Lawyer is now sending his minions in. And he says, black man here, Lupo Lawyer is right about fake outrage over the word. I don't know. You use the N-word with your friends in everyday conversation? Do you think that that's a good idea? Mel, your building has less than 1% coloreds. What building? What building are you talking about? I don't live in a building. My apartment building? What are you even talking about? That hurts coloreds more than Goode's words. Okay. All right. Let's hold on. Let's look into this guy because he wants his 5 minutes of fame. So let's give it to him. At least you came in with your $4.99 super chat, so that's cool. Let's see. Okay, this is the first time that you have ever commented in my channel at all. And you joined on June 23rd, August 23rd, 2024. Are you a puppet account, a sock account of Loophole? And whose profile picture did he steal for this one? What building are you talking about? Thank you so much. So you think it hurts coloreds? Fake outrage over the N-word hurts coloreds. Wait, so you're a black man and you call yourself colored? That's interesting. Thanks for interrupting the class with your bullshit, because we know you're not real. But enjoy Block Island. You might run into Turtleboy over there because he's actually going there on vacation. At least you paid me $5, and I'll happily take your money. And you waited 3 days. You waited 3 days to come in and comment. So that shows a lot of tenacity on your part. Congratulations, sir. Well done to you. I'll take your $5 all the way to the bank. Because if you don't think that black people are hurt over Sean Goode's words, then you're just a moron. You're just a moron. And I can't help you. Nobody can. Tully was in on everything. And so here is what they're demanding. Okay, Karen, all communications, emails, text messages, audio recordings, or video recordings in Lieutenant Tully's possession for touching the following subjects: Karen Reeder family members, agents, attorneys, and representatives without any subject matter or temporal limitation. Yeah, let's find out why they wanted the bank records. Two, the 2021 black Lexus LX 570 SUV leased by Karen Reed. Yeah, we want everything involving the taillight. The death of John O'Keefe III without temporal limitation. Right, up until the present day. Every single time you talked about the investigation, it's absolutely discoverable. 4, John O'Keefe II, Paul O'Keefe, or Margaret O'Keefe from January 1, 2021 to the present. Yep. Want to know what you were saying to the family? 100%. 12 named individuals present at 34 Fairview Road on January 28th to 29th, 2022 from January 21, 2021 to the present. I guess January 1, 2021 to the present, 1 year prior, to show any prior relationships with any of these people. And if you don't have them, you don't have them. Just say you don't have them. Any member of the Canton Police Department from January 28, 2022 to the present. Any member of the Boston Police Department from January 8, 2022 to the present. Right. Remember, wasn't Tully also the one who found Jessica Hyde? Isn't he the one who recruited Jessica Hyde? Right. And he flew to LA to interview Natalie with Buchanan. That's right. That's right. Thank you, Fairy Raven. Fairy Tale Nails by Joe says Tully doesn't want to be deposed because it will expose the level of corruption throughout the whole system. Marcy, judges, DA, MSP, Canton PD, Haas defendants, witnesses brought in to cover it up. Olivia, again, pointing out that the bank and financial records were presumably sought in their intention to show a conspiracy, right, between Aidan and Karen. That Karen was compensating Aidan for reporting on her case by buying him a Lexus. And Deborah says maybe they were trying to see how much money Karen's dad had to help her fight this. That's another great point. Sheila says, on April 26, 2025, Turtleboy posted on X his bank records and Bill and Nathan Reed accusations of Karen Reed bribing Turtleboy with a new Lexus. Yep. Venus Blue pointing out the Hyde emails are interesting. Yep. It was Tully, right? He was all over it. He was all over it to protect Jennifer McCabe. Hiring Jessica Hyde was an attempt to protect Jennifer McCabe's 227 search. They needed someone to say that the 227 search didn't happen and he found Jessica Hyde. And the emails between him and Jessica Hyde are interesting. Oh, right. I'll allow it. Sai says, didn't he accompany the Lexus to Texas as well? Hmm. Shelby Ray says the subpoena was for the state grand jury in 2024 for Verizon, Lexus, and TD Bank. Was that for the grand jury? Was that for the grand jury that they were that they convened to try and indict the ham sandwich of Karen and Aidan for conspiracy to commit witness intimidation? Well, it had to be because that was the only one in 2024, right? Josie Lou pointing out May 11th of 2022, it was confirmed that experts had been retained to support Garino's findings. Yep. Everyone's got a great memory, right, Noni? That's why I rely on you guys so much. That's why it's so important to me that you put like only real information in the chat, because I rely on you. Tully was also present to oversee the testing of the vehicle chip by Shannon 1N Burgess in Texas, says Olivia. Tully was also a taxi service, right? Wasn't he shuttling witnesses back and forth? Josie Lou says correction on the year, May 11th of 2023. Thanks, Josie. He also picked up every witness from the airport, says Laura. Moving on to the requests. Anything having to do with 34 Fairview Road in Canton, Mass. Without limitation. Any dog owned by any member of the Albert family. Any federal investigation relating in any way to the death of John O'Keefe III. All communications with the Norfolk DA's office from January 28th, 2022 to the present concerning Karen Reed or any prosecution involving her. That's a good one. All documents and communications concerning Michael Proctor from January 28th, 2022 to the present. These are very well-drafted demands. All documents concerning any disciplinary investigation, proceeding, decision, or appeal concerning Lieutenant Tully's own conduct as an MSP employee from January 1, 2021 to the present. If there's never been any disciplinary investigations against you or proceedings, then it shouldn't be a very difficult request to answer, right? How is that unduly burdensome? All documents concerning any disciplinary investigation concerning Michael Proctor or Yuri Buchanan's conduct. 15, all non-privileged documents and communications concerning this litigation or any current, past, or potential litigation involving Karen Reed. Good. Those are very well-drafted demands. But, he says, the requests are not tailored to the claims in this wrongful death action. This is a wrongful death action brought by the O'Keefe family against bar establishments and Karen Reed. Lieutenant Tully is not a party. His relevance to this action, if any, is narrow and relates solely to his supervisory role in the MSP investigation that followed Mr. O'Keefe's death. What investigation? Number one. You were far more involved based on all of the things that people in the chat have just mentioned and the other things that I've been screaming about since the beginning of this stream for the last 1 hour and 43 minutes. You think your relevance is narrow? Okay. Shaggy. He was not present at the scene on January 28th or January 29th of 2022. Was not involved in the events giving rise to Mr. O'Keefe's death. I don't think anybody suggested that you were involved in Mr. O'Keefe's death. Did not serve alcohol to any patron and was not a primary investigating officer. Let me ask you this. Who was it that gave out the scavenger hunt list to the CERT team that arrived at 34 Fairview in the evening hours in the dark on January 29th, 2022, after the front lawn aka crime scene, was left unsecured all day. Who is it that drafted the scavenger hunt list for the CERT team that said, we need you to find some taillight pieces and a sneaker? Go. Of course it was. Inverted sneaker, aka Gail, says Tully. Belinda says Tully was there on the 29th with the CERT team. Well, we don't know. You know why we don't know? Because there's no log. There's no log of who was on the scene. Ed Wallace, forensic guru, has told us that every crime scene is supposed to have a log, and there's supposed to be a guy in charge of the scene keeping a log of who enters, what time they enter, who leaves, and what time they leave. Mom to Nick and Allie says, does he actually think he can gaslight the court? Wow. It was a scavenger hunt list. What are we looking for? Oh, you're looking for some taillight pieces and a sneaker. Like literally that's what they were told to look for. And Tully told them that that's what to look for. And then after they found it and they were doing their shoulder to shoulder grid search on the front lawn at 34 Fairview, after they found a couple of pieces of taillight and a sneaker, the search was called off. And they were like, that's good. That's good. We got what we need. We're good. And whoever was like the commander of the CERT team said, well, do you want us to come back like when the snow starts melting to keep looking for evidence? And Tully was like, no, we're good. We're good. Buchanan said that he just told his guys to like, I don't know, on your way home and on your way to work, just shoot by, shoot back, drive by 34 Fairview on your way home and to and fro, just in case any of the evidence reveals itself. In case any other evidence reveals itself, and reveal itself it did. Many more pieces of taillight were found in the weeks following January 29th of 2022, all by members of the Massachusetts State Police, and one giant dinner-sized piece by Ken Berkowitz, who was on medical leave as the chief of the Canton PD, who wears, I don't know, Coke bottle thick, or at the time, he is now at the Endless Heaven Buffet. Rest in peace, I guess. He wore Coke bottle, you know, thick glasses, but he was able to spot eagle-eyed Ken Berkowitz from his moving car, I don't know, a dinner plate sized piece of red taillight, called it in, had them come and collect it. You know who never found any pieces of red taillight? Any of the occupants of 34 Fairview Road who would have been in and out of that house many times a day. Weird, isn't it? And also, the thing is, the CERT team is like a search and rescue team. They're supposed to go out and look for missing people. For example, in the missing persons case, which turned out to be a murder case of Anna Walsh, the CERT team was called in to look for her, bring the canines. Katie McLean, too. I think the CERT team came in to look for her. Dr. Harry Turk was tried and convicted of manslaughter in the death of Katie McLean, but the CERT team came and, you know, dragged the pond where they found poor Katie McLean, God rest her soul. But the CERT team is not an evidence collection team. There is an evidence collection team. They weren't called to 34 Fairview. I wonder why. It's a rhetorical question. None of the 15 document categories is calibrated to that narrow relevance. Instead, they demand the entirety of Lieutenant Tully's communications, documents, and records touching the O'Keefe matter in all its dimensions. Oh, yes, it does. Criminal, civil, federal, disciplinary, over a period of more than 5 years. This is not proportionate discovery directed at a non-party supervisory witness in a wrongful death action. That's because this is not a wrongful death case. It's a murder. And the murderers and the people who covered it up may still be roaming the streets. Are you really that bad of an investigator? Apparently. It's rhetorical too. It is a wholesale demand for every piece of paper and every electronic communication that Lieutenant Tully has generated or received in connection with the most prominent and heavily litigated matter of his career. Well, the reason it's prominent is because you did zero investigation into the murder of John O'Keefe. That's why the world is watching. There's over 7,500 people watching right now, and this video will go on to receive many more views than that. maybe you should have thought about that before you supervised the investigation into the murder of a Boston police officer found on another Boston police officer's lawn and did a shitty job of it at that. And that is exactly why all of this stuff is relevant and discoverable, because this is the most prominent and heavily litigated matter, not just of your career, but I would say of Norfolk County history, maybe even Massachusetts. Might be up there with Whitey Bulger. I don't know. And the Salem witch trials. The burden this imposes on a retired officer without the institutional resources of an active government agency is substantial and unjustifiable on the record presented. Good. Just hand over your phone and let's extract it. How about that? That wouldn't be much of a burden at all. Just turn your phone over. You know, your personal phone that you use for public business, because it's discoverable now. Just turn over your phone. Let them extract it. How about that? That's easy. That would be no burden for you, except turning it over. Whether it's discoverable is one thing. And pretty much everything that an argument, if you can make an argument that is something is even just a little bit relevant, pretty much everything is discoverable in a civil case. Whether or not it's admissible at trial is an issue for the trial court judge. But discoverability, pretty wide latitude there, sir. You know that. Or you should. Or your lawyer should, but you know, your lawyer's just getting paid by the page and by the 10th of an hour, so what does he care? Several categories are independently objectionable. Request 13, demanding Tully's own MSP disciplinary records, is particularly improper. Sounds like you doth protest too much. Because we've seen the little slap on the wrist you got where I think they took like 5 vacation days away. Are there more? Personnel and disciplinary records of law enforcement officers are subject to heightened protection under the general law. Such records are not freely obtainable through civil subpoenas directed at the officer himself, and their compelled disclosure raises concerns that go well beyond proportionality. Okay, well, the fact that you're fighting it so much makes me think that there's a lot more in your history revolving disciplinary matters than we know. This is my guess. Moreover, this request is transparently aimed not at developing evidence relevant to this wrongful death action, but at obtaining material directed relevant to the federal action, in which Lieutenant Tully's disciplinary proceeding is expressly alleged in the amended complaint. Yeah, because everything that you did to Karen Reed is included in that lawsuit, and everything that you did to Karen Reed is her defense in this lawsuit about the car accident. What part of that don't you understand? Request 6 and 7 demand every communication Tully has had with any member of the Canton Police Department since January 28th of 2022, a period of more than 4 years, with no subject matter limitation whatsoever. Well, it could also go to bias, as we've learned through the recent revolting and heinous release of text messages and voice memos and WhatsApp messages specifically of Sgt Sean Goode of the Canton PD. Were you involved in those? And also in the total phone extraction of Michael Proctor. We know that you were involved in those. I don't know if we know yet, but we'll find out. I don't think this is true. The Nick and Casey said, Karen and John O'Keefe had iPhones, the McCabe's and Alberts had Androids. I don't think that's true. I don't think that's true, and I'll tell you why. Because when Michael Proctor issued a subpoena for the geofence data at 34 Fairview on the evening of January 29th into 28th into January 29th of 2022, he only requested it for Android phones, not iPhones. So I don't think they had Androids, because then they would have been included in the geofencing. Allie McCabe has testified she had an iPhone. Colin Albert has testified that he had an iPhone. Right? Yeah. Thank you, John. Jenny, they all had iPhones. Everyone had iPhones. That's why Proctor couched his subpoena the way that he did. So it would only return Android information because nobody had one. A retired officer cannot be expected to locate, collect, and produce 4+ years of departmental communications in response to third-party subpoenas, particularly where those communications span agencies and matters far beyond the scope of this wrongful death action. I don't know. Methinks Tully's a little young to retire. So why did you retire, Tully? So that you could use it as an excuse when they wanted discovery from you that you're now retired and you don't have anybody helping you anymore, and so you can't possibly be burdened to give discovery. 14 and 15. Demand records of third-party disciplinary proceedings concerning Proctor and Buchanan and records of all litigation involving Karen Reed, including the federal action itself. Okay, but if you don't have it, just say you don't have it. If it's not in your possession, custody, or control, just say that. Why doth you protest so much? Documents generated in or related to the federal action which Reed is suing Lieutenant Tully are not obtainable through a subpoena directed at him as a non-party in this case. Okay, so just respond to the request and say you don't have it. You don't need a motion to quash unless you really, 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 really don't want to appear for a deposition. But we all know they're going to get your deposition. This just makes you look more guilty of something. This is like, in my opinion, all of this fighting about producing this stuff is consciousness of guilt. If you don't have it, just say I don't have it. Right? And yes, he's a teacher now. He's a professor. He's working for an agency where he's teaching such things as cell phone forensics. We looked at that the other day. We did. Oh. Documents generated in or related to the federal action in which Reed is suing Lieutenant Tully are not obtainable through a subpoena directed at him as a non-party in this case. Well, if he's got possession of them, just say you have them. If you don't have them, just say you don't have them. The request 15 is particularly circular. It asks Lieutenant Tully to produce, as a non-party witness in this wrongful death action, documents relating to the federal civil rights case in which he's a named defendant and in which formal discovery has not yet opened. See, the appropriate alternative of relief is a substantially narrowed protective order. If the court declines to quash the subpoena in its entirety, Lieutenant Tully respectfully requests, well, where's the retired part? That the court enter a protective order, narrowing down the document requests and depositions as follows. Stay the deposition pending the July 14th hearing on Lieutenant Tully's motion to dismiss in federal court and the resolution of that decision on the motion. So the federal court's threshold determination of whether any claims survive against Lieutenant Tully may inform the scope and necessity of his deposition testimony in this proceeding. Again, nothing to do with that. Limiting document productions to material specifically concerning Lieutenant Tully's direct supervisory communications regarding the O'Keefe investigation. What investigation? During the period January 29th, 2022 through December 31, 2022. Why? Why do you want to only go through December 31, 2022? That's ridiculous, because the persecution of Karen Reed was ongoing until her acquittal in 2025, July. Or June. It was June, because the 1-year anniversary of her acquittal just passed. Excluding request 13 in its entirety, as Lieutenant Tully's own personnel and disciplinary records are protected from compelled third-party disclosure. That makes it even more interesting now. What's in his disciplinary history that he doesn't want to turn over? Excluding requests 14 and 15 in their entirety, as they seek records of parallel proceedings and third-party disciplinary matters that are not within Tully's custody or control and are not relevant to this action. Well, why are you afraid to swear under oath that you don't have them then? Limiting requests 6 and 7 to communications specifically and directly concerning the O'Keefe investigation during the period of only January 29th, 2022 to December 31 of 2022. Conclusion. Karen Reed has twice attempted through the federal pleading process to establish a viable factual case against Lieutenant Brian Tully. I mean, Stevie Wonder can even see it. Stevie Wonder can see that you're involved. She filed an original complaint. Lieutenant Tully moved to dismiss it. She filed an amended complaint. Lieutenant Tully moved to dismiss that as well, demonstrating, as set forth in detail in Exhibit A, that the amended complaint's expanded allegations remain conclusory. rely on impermissible group pleading and fail to plead the specific facts that the Section 1983 claims require. Let me tell you something, okay? I've been a civil litigator for over 3 decades. Over 3 decades. In nearly every single civil case, complaints are amended. In nearly every single civil case, motions to dismiss are made by the defendants prior to discovery even starting. Okay? There's nothing a defendant likes more than getting his or her case thrown out on papers before discovery starts. It's called a motion in lieu of an answer. He did it. Tully did it. It's likely not going to be granted, but it happens in every single civil case. You're acting like this is crazy. Not crazy. You're entitled to amend your complaint once as of right. Ridiculous. In the federal action, Karen Reed successfully opposed co-defendant Proctor's motion for a pre-conference third-party discovery. Again. He doesn't need to produce anything to Michael Proctor to help him with a cheat sheet for his deposition, just like she wouldn't have to provide you with anything as a cheat sheet for yours. For the foregoing reasons, this court should quash the subpoena and document requests served upon Lieutenant Brian Tully, retired, in their entirety. In the alternative, this court should enter a protective order 1, staying the deposition until after the July 14th, 2026 federal hearing and its resolution, which could be months until a decision is rendered in that case by a federal judge. And 2, substantially narrowing the document request to the specific categories identified in Section 2C above. And the court's going to say to Tully's attorney, XOXO, here's the attorney, Timothy M. Burke, Esquire, out of Needham. Needham. You know what that reminds me of? Okay, this is a total Gen X reference, but if you tell me, then I'm crazy. Do you ever remember flipping baseball cards in elementary school? Needham, got him, Needham, got him, Needham. Well, anyway, he's in Needham, Mass. And this was served on June 18th, 2026. The reason why it was not filed until the 25th is because in Massachusetts, you serve your motion on the other side. They respond to the motion, and only after the response is filed is it filed with the court. And I remember hearing Aaron Rosenberg talk about this motion, saying that he was blindsided by a motion to quash by Tully because that deposition was scheduled for July 8th. They had just rescheduled it, and now he gets this motion. And he said that he was going to file his opposition to the motion that same day, and he was hoping, because the burden now was on Tully's attorney, to file the motion as a package to the court. He was hoping that it would be filed right away so that the judge could see it right away. And whatever it is in Karen Reed's opposition, which we are going to read next, gave the court, Judge Gildea, some more grave concerns, and he required Karen Reed's team to supplement this opposition by yesterday at noon. I don't know if it's hit the docket yet, but let's go to the chat for a moment. Take a look at your thoughts, questions, comments, and concerns. Double Trouble said, wasn't Tully the only MSP to go to 34 Fairview? Let me think about it. No. You mean on January 29th? Lank. Lank is MSP, right? Remind me, because now I'm getting totally confused. Lank, Sergeant Michael Lank, MSP or Canton? I think he's MSP. Lanka is like the Ray Donovan. He's Canton PD. Okay. Lank, Canton, he's the fixer. So Michael Lank is the Ray Donovan of the Albert family. He's been fixing their family business for decades. Okay. So did any MSP go to, thank you. You guys have corrected me, and that's a well-deserved correction. The CERT team was MSP. Gallagher also Canton PD. So remember, first on scene were Gallagher, Saraf, Goode, all Canton PD until Canton PD got recused after John O'Keefe died, allegedly. And then MSP came in. And so Canton would have been recused when they were searching for the taillight. And so was it Connor Keefe? Yeah, Trooper Connor Keefe was there. Wasn't he the guy who was like allegedly like writing down when the taillight was found? I don't know if we have any confirmation that Tully was actually on scene. Yeah, recused yet still highly involved. Keefe and Tully were documenting evidence at 34 Fairview. And there were 2 MSPs searching that O'Hara recognized and maybe 3 more. We don't know. Did Garino go to the scene? Gallagher is Canton PD. But Tully was in charge of everything that day. Trooper Paul didn't go there on the 29th. Gallagher got a massive raise. So no, he definitely wasn't the only one because Connor Keefe definitely testified that he was there that day. June Mom says, I'm sorry, but wasn't Tully a witness in the trials? I rest my case. Thank you. Thank you for your 5. Veronica, thanks for your 10. Says, where else can you go and get the truth of the breakdown? I so appreciate you, Melanie. XOXO Cupcakes Rock. Thank you for your 10. New York Mom says, I love how you bring the facts and you look so gorgeous. Thank you. Fabulous. I appreciate your compliments. Thank you very much. And you pay me $5 to compliment me? What's better than that? Who's better? What better? Who has a better life than me? Carrie B says, maybe the ice cream truck is listening. Thanks, Carrie. Oh, I think so. I think definitely. I think they're definitely paying attention to everything that's happening right now. Overruled, sit down, says, excuse me, Mr. Lawyer, read the room. All roads lead to Tully. Thanks for your 5. Pammers says, sounds like Tully doesn't want to get back into that mud with Karen again. Effing can. Again. Effing can. Thanks for your 5. Tashai says, can Karen subpoena Proctor's bank records for the gift? We'll see. We'll see. It's unlikely, but who knows how deep this is going to go? Who knows? The feds could do that without a subpoena. Maybe they already have. Thank you, Tashai. All roads lead back to Tully. Says, I'm the problem. It's me. Lola, the good dog, says, did Tully have any connections to the McCabe's or Alberts? If anybody knows the answer, tag Lola, the good dog. Well, I mean, Tully, right, was the supervisor of the homicide squad that was assigned to the Norfolk DA's office, right? So he had to know Kevin Albert, who was a Canton police officer at the very least. But yeah, I don't know if his relationships with like Brian Albert and others has been explored as much as Proctor's have. That's a good question, Lola, and I'm sure someone in the chat knows. Stella says, thanks for always keeping it kind and classy, Melanie. Thank you. Oh my God. The $1.99 super chatters are here. Wait, except for you're not a troll. Tully prepped every witness with Lally, says Jenny. I mean, I love how, well, the trolls that come in with the $1.99 super chats, what's so funny about it is that's the only way that they can get in. Because if they haven't subscribed for 3 days, I think you can still put in a super chat. But you're cheap as F. Not that you're cheap, Jenny. But these people that are coming in to talk about the population of Black people on Block Island and such. Scott, all you need to do is check out the $1.99 super chats, and it's pretty easy. Just bot a troll. JP says this case is more than just a wrongful death case. Yes, it is. Thanks for being here for 8 months. Thank you so much, B Crumbs, for gifting 10 memberships. And to all of the new members today, there's like at least 30. At least 30. Welcome. Thank you, B Crumbs. You're an amazing contributor to the channel. On top says, Tully, keep that same energy you had with Karen and Aidan. You'll need it. You're a loser, guy. You're a loser. Jersey Lou, thanks for your 20. Says iPhone 11, Jen McCabe extracted second time. Okay, so Jennifer had an iPhone 11. It was extracted for the second time on May 31st, 2022, 9:56:26 p.m. Josie, you've got an eye for detail. I will give you that. It's Whack-A-Troll. Becky says, Whack-A-Troll, cheap fun for everyone. It is. The poor mods in here are playing Whack-A-Troll constantly, but we find it amusing. Your dad's favorite mom said, Tully also made the decision to bring Karen's car to Canton Sallyport. He testified to it. I love it. Roberta, thanks for your Venmo, says the 2 weak links, Colin and Proctor. They're weak and not very smart. The Haas defendants have to play every card right now to play, look over there, not here. I mean, it's interesting. Tell me if you feel the same way as Roberta. That perhaps Proctor and Colin Albert are the weak links, and so they got to do something about them. They got to just make it go away, right? Marie, thank you very much. Says, I love you. Love your show. Appreciate all you do. Something I would love for you to do is make a list and go over a description of all the characters one by one who have been involved in the case. Who are they? What they did? How they're involved in Karen and Aidan's cases? Marie, you know who has got great diagrams and spreadsheets and family trees? Emily C. Emily C is just one of the people who's done that. If you don't follow Emily C on all things social, you should do that. I think her YouTube channel is at Emily C, like SEEE. I think there's an extra E at the end. But one thing that we discovered recently in the FOIA request, and I can't remember what show it was in, inside the Commonwealth file for the Karen retrials was an actual chart of all of the witnesses and what they were going to testify to and how they were related. It was crazy. Do you guys remember that? I don't remember what show it was in, though. Lori said, did we know Judge Canoni is the site judge over Plymouth? Grave concerns. I don't know what that means. Site judge, S-I-T-E. Thank you, your dad's favorite mom, for your 5. And thank you, Lori, for your Venmo. All right. My touch screen's not working. Holly Johnson says, thanks for shining sunshine on the dark side. You're very welcome. You're very welcome. The world is watching. The world is here. If you are here today, if you are one of the almost 7,500 people watching right now, and you are watching from outside the U.S., tell us in the chat where you're watching from, because the world is watching. And I'm going to prove it to you right now. Just watch the chat. All right, let's look at defending Karen Reid's motion, the opposition to this motion to quash, because this is what gave Judge Gildea grave concerns to the point where he wanted more information filed by Reid's team by yesterday at noon. Haven't seen it yet, but we're going to see it. Look at South Africa, Greece, England, Scotland. A lot of Scots. I love my Scots. Scotland, Stockholm, Canada, Estonia in the house. Hi, Eve. Jane's here from London. Sadie from England. Finland is in the chat. Wales, Yorkshire, a lot of England, a lot of UKs, Australia, Denmark, Portugal. The world is watching, and they're all here. Perth, Norway. I'm telling you, we have a worldwide audience here, and not shutting up until every single last mofo who deserves it is in handcuffs. We have a handcuff emoji. Slovenia in the house. New Jersey. That doesn't count, Nona. New Jersey doesn't count. South Africa. Show me some handcuff emojis in the chat. My voice may be going, but my drive and my motivation and my passion is going nowhere. In fact, when I was just in London last week, I found a new prop for us. The classiest rubber duck I could find in Leicester Square. Lady Di. Lady Di is here. She's going to watch over us. She's adding some class to the prop bucket. Isn't she cute? She supplements my finger puppet that I found last week at a farm stand that makes noises. Sorry if your pets are going to be bothered by this, but this is the absurdity. Okay, this is the absurdity of Canton PD. They did a 36-page police report on investigation into little tiny rubber ducks that had stickers on the bottom that said Colin did it. Some of them had stickers on it that said IYKYK. They dug through the trash at Rich Schiffer's house, downloaded his Toyota Tundra text stream data to prove that he littered Monopoly money with that was stamped Justice for John O'Keefe and Colin did it in and around D&E Pizza. And some little teeny weeny rubber ducks were found around town with little stickers on them. Thank God Tim Bradle was able to get that dismissed, but he was charged with a whole bunch of crimes like littering and witness intimidation because Chris Albert said so. Gross. Here's Karen Reid's opposition. Let's take a look. Let me just see how long the actual motion is. Oh, okay. It's only a few pages. Okay. The opposition, I mean. Oops. Okay. This is defending Karen Reid's motion. Defending Karen Reid's opposition to the motion to quash, Tully's motion to quash. Okay. This is what gave Judge Gildea a panic attack and grave concerns. Sentence number 1. Apparently, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line by filing a motion seeking to quash his subpoena. Let's keep reading because we're going to look at the judge's order after this. And like the other subpoenaed non-parties, Jennifer and Matthew McCabe, Brian and Nicole Albert, and Brian Higgins, Colin Albert, and Julie Albert, who just didn't show up for her deposition on June 16th. Oh, so Julie Albert was basically just a no-show. Julie Albert just ghosted. For those of you who might have forgotten or who do not know, Julie Albert is the mother of Colin. Did she have to go wave goodbye to him on his way to preschool? Army preschool? Oh, please. Julie Albert just was a no-show for her deposition on June 16th. Are you shocked? Who all ignored Rule 45 requirement regarding valid objections to document requests. Tully now wants the court to credit his invalid objection and does not want to produce any documents either. Karen Reid respectfully requests that the court simply deny this motion immediately on the papers and without a hearing. As the court requested, this opposition will be short and is being served the same day, June 18th, as receiving the motion, June 18th. Hiccups. Hold on a second. Hold on. Oh, here's another troll wanting 5 seconds of fame. Look, are you willing to take here's the Goldie Fish coming in. The Goldie Fish comes in and says, are you, well, you did wait 3 days to actually chat here. Are you willing Oh wow, this is like the third or fourth time that oh my God, you've put this in the chat 1, 2, 3, 4, 5, 6 times today. Were you sent over by Loopy too? The Goldie fish, you put it in there 6 times, so you want everyone to hear it. What a jackass you are, apparently. Wants to know if I would be willing to take a polygraph test to prove that I really believe that Karen Reed is innocent, or will I continue to be a fraud? Oh, Goldie. Oh, Goldie. Goldie joined YouTube yesterday, June 29th of 2026. How did you even get in here? Isn't there a 3-day waiting period on this? Yeah, I'll take a polygraph to prove that I believe that Karen Reed would do. I'm sorry, do I work for you? Thank you so much for your suggestion. Have a nice day. Enjoy whatever rock you live under. It's hilarious, isn't it? So funny. You know when they come for me, that it's because everything I am saying and the court documents and I am reading and the opinions that I have regarding everything that I'm reading and the analysis is so effective that they are so afraid. They are so afraid because it's all coming out. It's all coming out. Turtleboy was right. It's all coming out. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. And apparently, Goldie Fish, someone like you doesn't understand medicine, science, physics, or injuries. But I've been a civil litigator for more than 30 years, and I've handled thousands of car accident cases. And the injuries sustained by John O'Keefe in no way, shape, or form were caused by a car. You know how I know? I don't know. Anybody in the chat ever get hit by a car? Anybody in the chat have a friend or a family member that ever got hit by a car? There will always be bumper marks or some sort of injury below the waist. Always. If a pedestrian is hit by a car. Okay? Don't give me your bullshit side swipe, pirouette, thrown in the air theory, exploding taillight, chewing up a man's arm in linear abrasions with only having bite holes in the sweatshirt as some sort of new theory in the world of physics and car accident engineering and accident reconstruction, because it didn't happen. Okay. The only injuries below the neck of John O'Keefe were what looks like an animal attack to his right arm. Okay. But, go on with your bad self. He had no broken bones. That if it's true that taillight hit his elbow or his arm would have been shattered at 24 miles an hour, 60 feet in reverse or whatever the hell they finally ended up on. Okay? It would have been shattered. Guess what showed up mysteriously at trial number 2? Guess what showed up? Oh, yeah, the x-rays of John O'Keefe's arm. No fractures. No fractures. All right, back to the papers. As the court requested, but I do appreciate the diversion because it's fun sometimes. As the court requested, this opposition will be short and is being served the same day, June 18th, as receiving the motion so it can get to the court quickly, but they didn't file it right away because it was up to Tully's attorney to file it, and he didn't file it until the 25th. 7 days later. Reed's counsel is also specifically requesting that Tully's counsel file his motion on the opposition electronically on June 19th so the court can rule on it immediately. But no, it has not been ruled on yet. Jamie says, you should make bracelets for your merch with some of the sayings of the day. The merch shop that I use does not offer bracelets. That is a great idea, and I love it. But here's what does have sayings of the day on it. The concert t-shirt, the Melanie Little XOXO tour shirt has all the sayings on the back of the shirt as a set list. It's really fun. Check it out. Merch is 20% off today. It's got all the sayings from all the trials or from mostly all from the Karen Reed trial and other things that I say on the daily. All right, here we go. Substantively, the court only needs to know the following limited information. And they limited it because the judge said, just tell me what I need to know from now on. Don't be giving me all the background BS. I don't need it. I don't care. Tell me what I need to know. So Rosenberg is doing just that. Reed's counsel issued a subpoena on May 19th, attached, requiring Tully to produce documents by June 1 and sit for deposition on June 11. On May 19, Tully's counsel accepted service of a subpoena. On May 19, Tully's counsel asked to reschedule the deposition, and both counsel agreed to July 8. Rule 45 requires a written objection to the subpoena within 10 days of service. Here, that period for objection expired on May 29th, by which date Tully did not serve any objection. On June 18th, for the first time, Tully sent an email attaching a Rule 45 objection and a motion to quash. Tully's counsel never previously communicated any of these concerns to Reed's counsel and failed to have a Superior Court Rule 9C conference. The argument here can be equally brief. Tully looks to quash or limit the deposition and document production. He makes two arguments, both fail. First, he argues that this court should somehow wait for the federal court case. There is not a rule or practice, and he does not cite any, that allows a subpoenaed witness to dictate the discovery schedule and the issuance of stays for a case and a court in which he's not a party. But even if there were, the alleged scheduling concern doesn't come close to the level of significance required to warrant a stay of discovery in this matter. Second, Tully argues that the document requests are too broad and unduly burdensome, but there's only one way that he can even raise this objection. He needed to preserve it under Rule 45 by making an objection within 10 days. He didn't. And it wasn't close. Moreover, his attorneys were involved from the very beginning, and they provide no reason in their brief, let alone good cause, for their failure. However, putting that aside for the moment, Tully's counsel didn't even attempt to communicate with Reed's counsel about narrowing prior to serving the motion, nor did Tully's counsel conduct a Superior Court Rule 9C conference. Rather, it appears that Tully simply watched the manner in which other subpoenaed parties, here's the other part that really gave Judge Gildea such grave concerns that he called his emergency meeting for tomorrow. Here it is. Rather, it appears that Tully simply watched the manner in which other subpoenaed parties have been handled in this case and made a calculated decision to ignore the agreement between counsel and go forward with the deposition on July 8th, ignore Rule 45 requirements, and hope that somehow this court will forgive it. The court has an opportunity here to demonstrate that subpoenas actually have meaning. I love when they throw the judge's words back at him, because the judge has said that. The court has an opportunity here to demonstrate that subpoenas actually have meaning. Attorneys' agreements to convene depositions on certain dates should be enforced, and rules of civil procedure actually have consequences. They're parroting the judge's own words back to him. XOXO, Karen Reed by her attorneys, Charles Waters, Damon Seligson, Charles Waters, Aaron Rosenberg, Arthur Maravellis, Thomas Tang, Sarah Shilby, Michael Bell, Alan Jackson, Caleb Mason, Elizabeth Little. All of them have been directed to appear tomorrow at 3 p.m. because of the Proctor stuff that was allegedly leaked that we don't even know what it is. Okay. But before we look at the reply, because there is a reply, because of course Tully's attorneys have to get the last word. Here's the judge's order. And the judge's order gives me grave concerns. Okay. Because now we have to dissect this a little bit more. He didn't rule on the motion. He just wants more information from Karen Reed's attorneys. And this was filed on the 26th, which was last Friday, the day after the motion was filed or made it into the court docket. Order requesting information from defendant Reed relative to the opposition to the motion to quash filed by non-party Tully. Okay, so here's what the judge has all got his panties in a bunch about. On or before noon on Monday, June 29th, which was yesterday, defendant Reed is requested to provide the factual basis for the following statements in her opposition. We just read it. He wants the factual basis for the following statements. Number one, quote, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, end quote. And two, quote, the manner in which other subpoenaed parties have been handled in this case. First of all, this is like a temper tantrum by the judge. Is he being overly sensitive? Were they even referring to treatment by the judge? Because the judge hasn't had anything to say about the McCabe's and the Alberts not showing up for their depositions and adjourning them because the motions to compel them to appear have not even happened yet. Right? And it says here, the manner in which other subpoenaed parties have been handled in this case. Well, Judge, you did a great job with Michael Proctor. In fact, you said you called BS on it. You said you're not providing any information about why he can't appear. Come back to me with information on why he can't appear. And then when they provided more proof to you and you impounded it, you didn't even buy their proof. So you, Your Honor, have handled the subpoenaed witnesses, Michael Proctor, the only one that's been before you so far, in a very excellent way. So I don't understand why you're now demanding that they provide factual basis for these things that were clearly not directed toward you. I would like you to chime in on this, because I don't think it was directed at the judge, because the judge hasn't ruled on any of the subpoenaed witnesses except for Proctor. And Karen Reed's team won that motion. Matilda says she's watching from the Netherlands. Thank you for your super chat. B Crumbs gifted another 10 memberships. Thank you so much. Welcome to the 10 new members. We have a lot of new members today. Thank you, B Crumbs. Jamie says, hi, Melanie. I don't understand how the feds, judges, or other officers haven't done anything. It's obvious what's going on here. I get corruption, but this, it's got to run deep, Jamie. It's got to run deep. So deep. It's pervasive in the culture. You can see that from the text messages and other communications, the WhatsApp messages that have been released, that Proctor and Goode both authored. How pervasive the racism, the misogyny, the anti-Semitism, the homophobia, how deep it runs. Even special needs people were not free from the hate speech of Sean Goode. And these are officers that were sworn to serve and protect their communities. And this is how biased they are. In yesterday's messages from Sean Goode, we did find that he did let one white guy off from whatever bogus charge he was going to charge him with, because he felt that he was born ugly and stupid. And so therefore, that was enough punishment for him. He let him go. He also alluded to charging people without any evidence, just like Michael Proctor alluded to shoving a nightstick up someone's butt, planting a bag of Coke on him, and tell him, you're coming in. It's pervasive, Jamie. Thanks for tuning in from across the pond. Stella Blue says, can the Haas defendants or the O'Keefes just decide to just drop the case because they realize it's not going to go their way? They could. Would they ever discontinue it? I don't know. But I don't think they're going to win. I think it's an uphill battle. I said this from the beginning. Diller's firm, the plaintiff's attorneys in the O'Keefe case, plaintiff's attorneys work on contingency, okay? That's why they make the big bucks. Here in New York, it's a 1/3 retainer, okay? For the sake of easy math. Let's say I have a client and the case settles for $9 million. Catastrophic injuries, fall from a scaffolding at a work site, no safety equipment, death. Let's say a case settles for $9 million. My fee is $3 million. And I get my expenses back because I pay for all of the expenses throughout the entirety of the litigation. And cases like this are expensive to bring. Look at how many depositions they're having. It's very expensive. That's why plaintiffs' attorneys make the big bucks, because they don't bill their clients by the hour. And so Mark Diller took this case, I'm sure, on contingency, because that's how it works. But if he doesn't recover anything, he doesn't get paid. So I don't know if they would drop the case. Could Mark Diller make a motion to be relieved as counsel and get out of the case if they have some sort of like fundamental disagreement? Yeah. And then the court would stay the case and give them time to find a new attorney. But how much money is he going to throw away before he realizes that this case is a loser? It's a loser. Karen Reeves was acquitted. And yes, sometimes civil cases can be successful when a criminal defendant is acquitted. Look at OJ. And there's been other examples of that. But this was not a car accident. It just wasn't. So they could, or the attorney could make a motion to be relieved. I don't know if either one of those things will happen. Stella Blue, thank you for your Grateful Dead reference. And be a 10. Denise Loves Ollie said, I Googled Tully and Karen Reed arrest. Yes, highly involved on both arrest and the investigation. Thank you. We know, we've been here. We've been through all the seasons. Beth Ellen says, I got hit by a car. It was going slow. I got bruised ribs and bruises on my legs. I got cited for jaywalking on Christmas Eve, no less. I'm sorry that happened to you. I'm sorry that happened to you. But yes, bruises on your legs and bruised ribs. And the car was going slow. What if the car was going 24 miles an hour? Your injuries would have been catastrophic, right? Battered ribs, shattered legs. Most pedestrians hit by the front of a car will fly onto the windshield and then get thrown. Thank you, Honey Bear. New tea. Don't give me your BS pirouette theory. Thanks for being here for 18 months. JP says if Karen Reed had backed into his arm at 24 miles an hour, his arm and shoulder would have been broken at a minimum, or at a minimum, severely bruised, not just the dog bites, right? Dislocated. Amanda said, sending love, can you say, I love you with all of my heart. I love you with all of my heart. If I don't see you soon, I'm going to die. You know what that's from, right? If you don't, that's Clemenza's meatball scene from The Godfather. Michael, tell the pretty girl you love her. I love you with all of my heart. If I don't see you soon, I'm going to die. Thanks, Amanda. It's almost as good as my impersonation of Jen McCabe saying, there's a man passed out in the snow. There's a man passed out in the snow. There's a guy. He's unresponsive. Could you send somebody? I don't know. He got out of the car and it could be a couple of hours and I think he's dead. April Lynn says, Garino seems to fly under the radar. Oh no. He has not flown under our radar, girl. We are all over Garino. He missed thousands of messages in the Birchmore case, and I bet he missed a lot in the Reed case also. Yeah, he also, was involved in Brian Walsh. We've given Garino his due. I think he's out on medical leave too. I think he's, rehomed. Cortisone, thanks for becoming a member. MS versus the U.S. Marine Corps. Semper Fi. Says Tully retiring is a him decision, his problem. Adulting hurts, but it was self-inflicting suffering. Let's go back to these two statements by Karen Reed in that opposition, and let's see why the judge is so upset about it. Because to me, these statements were not directed toward the judge, and if you disagree with me, please tell me that. You have a right to disagree with me, just, where's the little sign? Well, just number one, don't be a dick. But number two, be nice or leave. The rules here are really simple. The block button is how I keep my peace. And my peace is really, 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 really super important to me. Your peace should be super important to you too. All right, here it is. And the first line is what he has a problem with right away. Apparently, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line by filing a motion to quash his subpoena. Well, here's the thing. Karen Reed specifically says, here's who I'm talking about. Jennifer and Matthew McCabe, Brian and Nicole Albert, and Brian Higgins, Colin Albert, and Julie Albert, who just didn't show up for her deposition. Well, we saw none of these people made a motion to quash. There was a motion to compel for Colin Albert. They came in and made a whole, he joined the army. He's Conrad Birdie now. He joined the army. We can't possibly get in touch with him. It's a burden. It's a burden for him to serve his country. And now we're going to ruin his life even more by making him come out of basic training. The judge hadn't ruled on that by the time he released this, right? He made the ruling on Michael Proctor, which was in favor of the Reed team. So why does he think that this is directed at him? Buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions. The treatment that they're getting is just like they're just refusing to show up. And now the burden is on the Reed team to make a motion to compel, which they haven't even made yet. And the judge hasn't ruled on. So it's just weird. I don't think this is directed toward the judge. The second statement in question that the judge has a problem with is right here. The manner in which other subpoenaed parties have been handled in this case. Rather, it appears that Tully simply watched the manner in which other subpoenaed parties have been handled in this case and made a calculated decision to ignore the agreement between counsel to go forward with the deposition on July 8th. Right. Like Colin Albert just joining the army to get out of it. Like Jennifer McCabe, Brian Albert, Jennifer McCabe, Matt McCabe, Brian Albert, and Nicole Albert just saying we can't possibly be there until August because we have vacations. I think the judge is overreacting here. Tell me if you think I'm wrong. I want to know. But the judge hasn't ruled on any of this. People are saying it sounds like a dig at the judge, but the judge hasn't ruled on theirs, on their failure to appear. So he hasn't treated them any such way. Right? I mean, Jenny, I agree. It does sound like a dig at the judge, but but the judge has not ruled on anything yet. He ruled on Proctor, and that was in their favor. I think they're just talking about the way that they're just not showing up. So it's weird, right? Handled by their attorneys. Right, because guess who represents all of them? Tuxbury. Tuxbury represents them all. Jennifer McCabe, Matthew McCabe, Brian Albert, Nicole Albert, and Brian Higgins, and Colin Albert. Tuxbury represents all of them. That's a great point, Kraft Haskell. Tully simply watched the manner in which other subpoenaed parties have been handled in this case, right, by Tuxbury. Tuxbury's like, don't worry about it. I'll get you out of it. Here's the thing. I'm not saying Tuxbury advised them to have Colin Albert enlist. I'm not saying that at all. I also don't know that it was his childhood dream to be in the army. This is a man who's afraid of a turtle. Do you think he wants to go through basic training? And then Tuxbury comes in and talks about basic training being a burden. Well, of course it's a burden if you're used to sleep until noon every day. Maybe now and then slinging some slices over at D&E. Yeah, that would be a burden for someone who doesn't have the honor and integrity and desire to actively serve his country in wartime. Don't believe everything you read on Google, Susan. Don't believe everything you read on Google. I have no personal information that that's true at all. Yeah, it was Maddie, although he's arguing for Tuxbury. Tuxbury is the firm of record. It was Chris Maddie. They're on the same team. They're all represented by the same team and the same people. Tuxbury's been in conferences before, but yeah, that was Maddie who did argue that stuff on behalf of Colin. And you know, they're the ones who have been having communications with the Reed team. It's the entire firm, Maddie's firm and Tuxbury's firm, representing all the same people and just saying, yeah, no, we can't possibly see showing up. I don't think this was directed at the judge because the judge ruled in their favor. And so I think that this hyperbolic order for the Reed team to provide additional information by yesterday at noon, which by the way, I don't even know if it was filed yet, is a little out of line. Tammy says, I believe the judge is pissed because everyone keeps trying to dodge their depositions. That I agree that that's probably true, but he's demanding that the Reed team provide a factual basis for these sentences and these allegations. And I think the judge thinks that it's directed at him, but in dissecting it with you, I don't think they meant treatment by the judge. I think they meant treatment by their attorneys, like, yeah, don't worry about it. No big whoop. It's just a subpoena. We'll get you out of it. We'll just object and you'll be fine. Right? And then, Chris Maddie, talks about, he was supposed to come in, by the way, with dates for the deposition for Colin. And instead he comes in and says, yeah, I left 4 voicemails for, somebody to call me back. And like, I guess they didn't know who I was. And so they just didn't call me back. Love my 2 grandsons says, it shouldn't have said handled, maybe attorney attempts or something. Right. Maybe it should have said handled. The manner in which other subpoenaed parties have been pacified by their attorneys, something like that. Because it's all the same law firm who represents every single person who's trying to get out of a deposition, except for Tully. So did that give Tully the idea? Like, oh, I should just adjourn mine too. Because, no big whoop. Let's see what you guys think. Thank you, Virtual Juror, for reminding me that that was Maddie who was arguing about Colin. That is right. Belinda said, Tully retired 22 months before full retirement age and 1 week after the new evidence surfaced in Sandra Birchmore's death. That's interesting. No, he wasn't drafted. He enlisted, Dr. S. Bryan. He just enlisted. He just wanted to join the Army so badly. Like Conrad Birdie and Bye Bye Birdie. Jill, not Wendy, says, I'm Team Reed, but her attorneys need to stop the snark. This judge has already clearly said he wants facts only in papers. I thought they tried to stick to the facts here. Yeah, but there was a little bit of snark in there, but I just don't think it was directed at the judge. Lori says, Colin was too old for traditional boarding school. What about a teen torture camp? What about a wilderness camp? V-Kind says, and that Colin waited how many years to join? If it was something he wanted to do, he would have left years ago. And we have no draft, so we don't have the draft here. There is no draft. Everyone, please hit the like button. Yellow Lead Better is here. Thanks for your 20. Says, my aunt was hit by a New York City cab 8 years ago. Low speed, shattered hip and knee, multiple surgeries. She just passed in May. Oh, I'm so sorry for your loss. Working on getting part of her remains entombed at the Basilica of St. Patrick's Cathedral next month. Such a beautiful, beautiful church. I go there every time I'm in the city. You know who else had extensive lower body injuries? The elderly man that Helena Rafferty smashed into with her patrol vehicle in a crosswalk and hid from the public. That guy, he too had multiple surgeries to his knees and legs and other things. So Helena Rafferty, who used to be the chief of police of Canton, would know all about the injuries caused by a car accident. Billy says, Colin gets extra time. Proctor gets extra time. The others boycotted and asked for extra time. It's ridiculous. They can't handle the timeline. And the judge said subpoena should mean something. Right. Rhonda says, because all the others are putting off making excuses, and that's where they feel Tully is just following their lead. Yeah. Standing Stone says this entire case is bogus, inverted Sally Port films, and not a word from the DA or judge. So let's show the jury an inaccurate video, and it's fine. Right. Marie says that does the judge not see through their dodging the subpoena and delaying the dates? Libra says nothing is just coincidental with these people. That's right. All right. Yeah. Noelle says send him to a wilderness camp in Utah. Right. Hello, Missouri. Hello, Missouri. She's a Karen 2.0 is here. Dexter, save us from the Commonwealth. Oh, sometimes we have to put Dexter up in the corner. Let's do that now. There he is. There's Dexter. According to Nurse Kim, when Tully joined, it was 29 years fully vested and not 25, so he's grandfathered in. Okay. I mean, she does her due diligence, so if Kim said that, I'll adopt it. Here it is. Paul's Barbershop in Quincy is here. Hey, Missy Nick. Thank you for your 10. It's Paul's Barbershop in Quincy. You know what? I think I've been calling it Nick's Barbershop in Quincy because your name is Missy Nick. So I'm going to write it down so I can shout it out. And to anybody who's getting their hair cut today at Paul's Barbershop in Quincy, you can put the volume back on now, Missy. We did look at, did you see the video that I showed last night of the 2 Massachusetts State Police troopers, one of whom beat the bejesus out of the other one at a Quincy restaurant? Apparently it's not a bar. It's like a nice restaurant. It's called like the Real House or something, REEL. I don't know where all my pens went. Pen shortage. Usually there's 400 pens here. Paul's Barbershop in Quincy. Love you. Yeah, so that happened in Quincy. Thank you for your 10. Lola, the good dog, says if the judge follows media regarding this case, he must know about Proctor's text messages, yet he wants Reed's team to show Proctor kindness. Yeah. Yeah. YSL says judge having a fake fallout AF. Johnny says filed the day after Rosenberg scolded for Jackson quote by the guy who was away. Bad luck. He didn't see the scolding, methinks. Shame it pissed off the judge. Okay. Correction from Dexter Save Us from the Commonwealth. I should retype correctly. Nurse Kim said, when Tully joined, it was 20 years to be fully vested and not 25. So he's grandfathered in, right? That didn't make sense to me. 29 and then 25. Okay. Got it. Quinn says they've rehomed Colin. And now Proctor. Who are they going to rehome next? I don't know. But, Tully had to get the last word. So let's take a look at his reply, which was filed with the packet on the 25th. Here's the reply of non-party witness Lieutenant Brian Tully, retired, in further support of his motion to quash the subpoena and for a protective order. You need another introduction? This is a reply, sir. You don't need another introduction. Defendant Karen Reed's opposition does not seriously engage with the central ground of Lieutenant Tully's motion. Lieutenant Tully is a named defendant in Karen Reed's own federal rights lawsuit. I know you said that 300 times. Judge has scheduled a hearing on the motion. We know you said that 300. Why do you need to say it again? There's no need for a reply here. You said everything the first time. Unless there's anything new in here, this is a ridiculous waste of paper and money because somebody's paying you on behalf of Tully. Reed's opposition devotes a single conclusory paragraph to this issue, asserting without citation to any case that no rule or practice permits a non-party to seek a stay in a case to which he's not a party. Well, if there's no case and no rule, what is she supposed to cite? What is she supposed to cite? How does she cite something that doesn't exist? That is not the argument Lieutenant Tully made, and it does not answer the argument he did make, that this court has inherent authority under Rule 26C to protect a non-party witness from discovery whose evident purpose is to circumvent the case management framework of a parallel federal proceeding. This is like a parallel universe at this point. Forget about the parallel federal proceeding. We're in a parallel universe. Reed's opposition cites no authority for the proposition that such authority does not exist because none exists to cite. Exactly. Because nobody else would ever make such a stupid argument. On the question of timeliness, Lieutenant Tully does not dispute that his written objections were served after the 10-day period. Okay, so you're admitting that you had 10 days to object and you didn't do it. But the remedy for a procedural lapse in objecting to document requests is not to ignore the substance of those objections, and it has no bearing whatsoever on this court's independent and freestanding authority under Rule 26. Well, the judge knows all about his freestanding authority because he directed everyone to fly in for a 3 p.m. hearing tomorrow as if they have no other cases. Nobody's on vacation. Nobody has a life. And everyone lives within, I don't know, 30 minutes of the courthouse. Isn't somebody like on a vacation? Isn't Tuxbury away? Is he going to have to come back from his vacation to show up tomorrow? It has no bearing whatsoever on this court's independent and freestanding authority under Rule 26C to stay or limit a deposition separate from the document request where good cause exists. You haven't shown any. Reed's opposition conflates the two and asks this court to treat a procedural argument about document requests as if it disposed of the entirely separate question of whether her deposition subpoena should proceed in advance of the federal court rulings on whether she may maintain claims against Lieutenant Tully at all. It doesn't matter if he's a defendant. He's not a defendant in this case, but his testimony is important to disprove the O'Keefe's theory that Karen, I said theory, I didn't say you, that Karen's defense is that it was not a false narrative. She was framed. There was no investigation into the murder of John O'Keefe because all they wanted to do was pin it on the girl. That's her defense. This is so stupid. The late service of written objections to the document request does not waive Lieutenant Tully's independent grounds for a protective order. And this court retains discretion to consider the objections on the merits. He's acknowledging right here, I failed to object within 10 days, but, abada. And they're going to go on for more pages and more pages and more pages. Is there anything new here? The court retains discretion to consider document request objections, notwithstanding the delay. Well, if you knew it was 10 days, why didn't you just object in 10 days? Did you really think your client was going to really show up for a deposition? The court retains discretion to consider objections served outside the window of 10 days when the requesting party, meaning Tully, has suffered no meaningful prejudice and where the objections raise substantial issues going to the propriety of the request themselves. So you can just sleep on the request? Yeah, put it together and what have you got? Bibbidi, bobbidi, boo. Okie dokie, I needed that laugh. Iowa says, I rewatched Colin's testimony the other day from the first trial. Yeah, they don't want that kid anywhere near a deposition. I mean, it's kind of drastic though, isn't it? Kind of drastic to join the army during wartime. Thanks, Karen, for becoming a member. Nobody wants to be deposed first, says Joanne. Thanks for being here for 15 months. Tortoise Interference says they're used to writing their own timelines. That's right. Remember Denise Galvin, Jennifer McCabe's sister, was the scrivener of the timeline. I still want to see that timeline. Where is it? Everyone, please hit the like button. Helps the algorithm. The world is watching, but we need more of the world to know about this. KBH says, I think the Reed team is getting frustrated with the Colin deposition stuff. Seems to me they feel more can be done to get him home. Yep. Not just leave 4 voicemails. Hi, virtual juror. Thanks for your 20. As VAB scores are protected by the Privacy Act, Colin would have to request his score from his MEPS Met recruiter. And there are other reasons for 3-week school beyond low ASVAB score. I like to dig. Thank you for digging. I don't know anything about that. There's somebody on TikTok who posted a whole thing that she said she had his file and she knew all this information. I don't know who that person is because it was the first time I had ever seen anything from her. But yeah, I don't know how anybody would know that. And so thank you for your 20. And you too like to fall in the rabbit holes just like me. Here, Reed cannot identify any prejudice flowing from the timing of Lieutenant Tully's objections. The deposition was rescheduled by agreement of counsel from June 11th to July 8th. A fact that Reed's own opposition concedes. That rescheduling necessarily extended the practical timeline. Okay, blah, 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 making excuses for why they didn't object timely. And there's 15 document requests. It's so burdensome. His own confidential personnel and disciplinary records should be protected because I guess there's a lot more in them than anybody knows or thinks. They're saying our objections are so substantial that the court should, forgive the fact that we didn't object within 10 days. And here it is. Here it is. They go to the heart. These are not insubstantial or technical objections. They go to the heart of whether a non-party witness may be compelled to produce his entire professional life's communications touching the most heavily litigated criminal matter in the Commonwealth in recent memory. And that's exactly why, in my opinion, they absolutely 100% should be forced. Tully should be forced and compelled to turn them over. The power of Christ compels you. This is it's like an exorcism. It's like this entire Norfolk County needs an exorcism. Is there any priest in the Commonwealth that would come in and do an exorcism on Norfolk County? Because this is insane. Nancy, thank you for your very generous $100 super chat. And your puppy is adorable. Is that a Burmese? Mountain dog? My eyes are shot, but it looks like it. Nancy says, with her $100 super chat, Melanie, is Colin going into the Army? On our side, because that's concerning. Yes, he's going in on the American. Yes, he's going into the U.S. Army. He is. Thank you, Nancy, for the $100 snark. You win. Adopt, never shop. You know what? Let's give away some trucker hats today. Stick with me, and we'll have a giveaway. We'll give away some trucker hats at the end of the stream. That's hilarious. You're very funny, and I love you guys, and you make me laugh every single day. Everyone could bring white sage for the next courthouse meetup. Oh my God, that's such a great idea. There is not enough sage in the world to cleanse that county, and I feel sorry if you live there because I know a lot of you live there, and you know how much I love you. Guess how much I love you. That's one of my favorite children's books ever. This is how much I love you, is that I think that there should be a lot of white sage for the next courthouse meetup. Everyone should bring sage. They may not like to burn it, but you could at least just wave it around. I usually have my sage with me right here. I always have a sage candle handy. But I don't. Quinn says, okay, if this were any other profession, would they need to turn over their employment records? But here's the thing about Tully being law enforcement is that if he has been professionally disciplined, it may not be admissible at trial, right? But it is discoverable, because if he did some egregious things in the past that he just received a little slap on the wrist for, it would go to the heart of the case that this man should have been nowhere near the investigation of the murder of John O'Keefe if he had done things in the past, like, I don't know, doctor, proctor evidence, plant evidence, who knows? I see where you're coming from, but it absolutely 100% is relevant to the defense of Karen Reed, because the O'Keefes are accusing her of spreading this false narrative that she was framed. How does she prove that? By proving that she was framed, or that these people had a motive to frame her, or that they did zero investigation into the murder of John O'Keefe, and therefore everyone pointed the investigation at her because she wasn't one of them. She was not one of them. This court should not decline to consider these objections on their merits based solely on the timing of their service, particularly where Reed identifies no prejudice and the underlying requests are as sweeping as they are. Reed's opposition does not meaningfully address the parallel federal, again, the parallel universe. And they're going to repeat themselves some more. He's a defendant in the lawsuit in federal court, blah, 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 blah. They should wait and listen to hear what Judge Casper does about tossing out the case against Tully, which is not going to happen and has nothing to do with it. And I think the judge is going to see right through this. Like Alanis Morissette would say, I see right through you. Yada, yada, yada. Yacht today, Satan. Yacht today, Satan. Lieutenant Tully is willing to confer pursuant to Superior Court Rule 9C and remains open to a negotiated resolution. Oh, now you want to negotiate, Tully? Is this like a hostage negotiation? Hostage. Notice how hostage starts with Hos, H-O-S. That's interesting. There was a hostage video in this case. Remember the video that Michael Marcy made in his conference room where his law reporter books were upside down and out of numerical order? Where it looked like someone was holding a weapon to his head off camera and having him read from a script about how Colin Albert did not commit murder. The harassment of the innocent witnesses in this case must stop. It needs to stop. Evidence shows that John O'Keefe did not go into the house at 34 Fairview on January 29th, 2022. Michael Proctor did not respond to the scene at 34 Fairview. He could not have planted taillight. Michael Marcy mentioned Colin Albert's name. Zoe, if you're here, give me the stats. Michael Marcy mentioned Colin Albert's name in that hostage video in August of 2023 more times than he mentioned John O'Keefe. Karen Reed has perpetrated a false narrative. Cases should not be tried on the internet for a reason. This is the first statement of its kind that I have ever made in the history of my career as district attorney. It wasn't a very good accent, but just an Earthbound Misfit says, your Marcy sounds like Mayor Quimby from The Simpsons, and I'm here for it. The harassment of witnesses needs to stop. Oh, Juice Life is here. If you don't follow Juice Life on Instagram, please do. She's a juicer. She gave me a juicer, and I love juicing. Juicing will change your life. Just juice celery. Celery juice has changed my life. It may change yours too. Go follow at The Juice Life over on Instagram for all kinds of juicing recipes. I also love juicing beets with my juice, but I digress. The harassment of witnesses needs to stop. But now Tully is he remains open to a negotiated resolution. Wow. Celery is not salty juiced at all. Asking for an enemy. Tully was present, Brit being human, for every witness, every Commonwealth witness prep. He gave rides to all the Commonwealth witnesses, right, when he picked them up at the airport. He was responsible for finding Jessica Hyde to protect and or defend Jennifer McCabe. Cucumber, pineapple, celery, and lemon juice. Throw a beet in there too. It makes it red and it's really pretty. And beet juice is really good. I'm not a fan of beets. I don't like to eat beets raw or otherwise, but in juice, they're really good. Just don't put too much beets in there. If you know, you know. You might think you're dying. Stop it. Stop it. Where can we buy merchandise? We'll get to that after this. Hold on. The merch store is linked in the show notes below this video. All right. And then we'll do some giveaways. And then I want to go lay in the sun because it's 2 p.m. and it's still sunny outside. And then blah, blah, blah. They didn't do a 9C conference. And to the extent the court would find it useful, we're willing to. We're willing to confer. Now we're willing to. And for the foregoing reasons, Lieutenant Tully respectfully requests this court quash the subpoena in its entirety, or in the alternative, enter a protective order staying this deposition until after the federal court hears the motion and rules on it, etc., 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 XOXOXO. And we want you to substantially narrow all the documents requested, XOXO, for the non-party witness, Lieutenant Brian Tully, retired, by his attorney, Timothy Burke, Jared Burke, of the law offices of Timothy Burke. That's what I said. That's why I said don't put too much beets in there. XOXO. Taco Rocks pointing out the obvious. Tully got a new job, and the chances are he doesn't want them to get the goods, right? Because then he'll lose his new teaching position. He's got a teaching position now. He's teaching police officers how to investigate homicides. Fantastic, right? Isn't that just fantastic? That's a joke. Let me close some of these windows on my computer because it's getting really drafty in here. Let's look at the merch for a second, and then let's look at the federal, not federal. These are state wiretapping charges caught by Meredith O'Neill for wiretapping, illegally recording Aidan Kearney back in December of 2025. Have you guys seen this yet? Meredith O'Neill, former girlfriend of Aidan Kearney, who may or may not have released his phone extraction, unclear, has caught some wiretapping charges in Leominster. You haven't seen it? Oh, okay. Don't worry. I've got it for you. I got you guys. I got you. Let's get rid of Alvin Campbell because he makes me sick. I don't want to look at his face again. Hold on. Let me go to my own show notes so I can pull up my own merch shop. Hold on. If you go right underneath this video, it says there's a little fire symbol, and it says merch right there. And then you just click on that and you get to this link, which is here. And here's the merch shop. And if you want the discount, it expires today. You have to click on this coupon up here. I know it's stupid. They don't apply it automatically. So here it is. Expires today, 20% off everything. Click redeem, and then it says redeemed. And for the person who was asking before about all the sayings on the shirt, here's the tour shirt. It also comes in black body with white sleeves, which is I like that one more. Let me find it. But it reminds me of the old time, Gen Z, Gen X, these concert shirts. Remember these concert shirts? Look, it says Attorney Melanie Little, XOXO tour. This is from 2025. This is the 2025 tour shirt. And it says, join the snark tank. Attorney Melanie Little, blada, blada, blada. And the price on this one is, it goes all the way up to 3XL, $35, but it's on 20% off right now, everything. So here's the sayings on the back. This is the set list. Oh, so you bus mommy got yours yesterday? Whoop, whoop. And for those of you who were here through 2 seasons of the Karen Reed trial, this is the set list, beginning with God Save Us from the Commonwealth, Call Me Alice, Show Me the Papers, The World is Watching, Grave Concerns, Talk Amongst Yourselves, There Was No Collision, Buy the Tickets. These are things that I say all the time, some phrases that I have coined, some that came from court papers. Buy the tickets. Pin it on the girl, under her eye. She's telling them everything. We're not buying what you're selling. Upside Down, Inside Out Narnia of Norfolk County. All Hail King David. Alessi Scissorhands. Remember when we made these things up? Yes, you can order Ireland. They will ship internationally. They absolutely do. Hello, have you met me? Never Lie to the Ice Cream Truck. One-way ticket to Block Island, followed by Hyperlink Me. For the Love of the Traveling Mary closed out the show. And then you got two encores. We Ain't Got No Quit. And then encore number 2, I Love You With All of My Heart. Because I do. And you know that I do. So there's that. And then also, not only do we have this, we have the I Went to Cancun with Attorney Melanie Little design that I was telling you about earlier. Look, you can even get throw pillow covers. You can get throw pillow color. How cute are these? All different colors. It looks like it fits maybe like a 17-inch pillow or something, an 18-inch pillow. We have baby wear because there's a lot of people who have babies and grandchildren. Because even the babies should be saying, I went to Cancun with Attorney Melanie. Look, there's a bib. There's a baby bib. There's a beanie. You guys wanted a beanie. Look at the little onesies. I mean, how cute. Tie-dyed bags. There's a dog bandana. You know whose dog wears that bandana? Kelsey Fitzsimmons' dog. Oh, wait, is her it's not a pillow, it's a pillow cover. You have to put your own inserts in, but yes, little teddy bears that say I went to Cancun with Attorney Melanie Little. Look, you can change the t-shirt color. Ooh, I like the yellow. Kelsey Fitzsimmons' dog Maverick has this bandana because one of you amazing viewers sent it to her. And also, the hats, which are on sale, the trucker hats are $11.99. Hang on. There's mugs, there's bags, there's caps. Here's the trucker cap, which I think is super cute. I ordinarily don't like trucker caps. It's $11.99 if you put it in the cart and go, and then it's 20% off. I usually don't like a trucker cap, but a trucker cap has its place, especially in the summer because of the mesh back. It's not so hot. You can use it for gardening. You don't care if it gets dirty. It can get wet. And so we'll give a couple of these away. You just got to, if you win, you got to tell me what color you want. So there's this, this light blue. There's black. No, this is navy with the white in the back, the white mesh. There's, oh, all right. The opposition to Tully is up. Well, we read the opposition. You mean there's like another reply? All right, just hold on a second. This one is all black. And this one is black in the front and white in the back. You don't have to sign up to win yet. It's gonna be just based on being in the chat and participating in the chat. So just hold on a second. Let me check my inbox. Thank you, Michelle, for your Venmo. She thanks for all that you. Thank you, Kyle Sharkey, for sending this to me. Thank you for all that you do for the class. She says, "Okay, thank you, Kyle. I'm just going to download this so I have it in one document instead of separate JPEGs. So hold please for one moment while I get the thing that Karen Reed was supposed to file yesterday by noon. It has now hit the docket. because everything always happens when we're live on the internet. It's a good thing I'm able to pivot on a dime, eh? Eh? It's a good thing I'm able to pivot on a dime. All right, hold on. I just gotta find the document. Which one is it? Oh, please. What is it called? It's a response to the court. I don't know why I can't find it, but I got it here. Just hang on. I have all the pages, but I have to upload them in a certain order. Okay, forget about that. That's this. Put that there. All right, here we go. This is defendant. It's too sensitive. My mouse is too sensitive. Stop being so sensitive. I prefer to download it and have instead of having it in a window, but this is all I got right now. So you get what you get and you don't get upset. Defendant Karen Reed's response to court regarding opposition to motion to quash filed by non-party Brian Tully. In response to the court's request, docket 135, the request, defendant Karen Reed provides clarification as to two statements contained in her argument against Brian Tully's motion to quash, which are presented below, along with additional portions of each that clarify Reed's meaning and were not included in the request. 1. Give me a second to download this because this is going to make me absolutely insane, as if I'm not insane enough already. Hold on. Oh, please. All right, let's do it this way instead. It's a lot of work that goes on behind the scenes here that you don't know about. It's only 2 pages. Don't worry, it's only 2 pages. And it's just me. I'm a one-woman show over here. Here you go. All right. Defending Karen Reed's response to court regarding opposition to motion to quash filed by non-party Brian Tully. In response to the court's request, docket 135, defendant Karen Reed provides clarification as to 2 statements contained in her argument against Brian Tully's motion to quash, which are presented below, along with additional portions of each that clarify Reed's meaning and were not included in the request. Thank you, Kyle Sharkey, for sending this to me. 1. And this is the quote. Apparently buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, subpoenaed witness Brian Tully now seeks to stand in the same line by filing a motion seeking to quash his deposition. Emphasis added. And it says apparently is bolded and underlined. Number 2. Rather, and this is a quote, and then it appears is bolded and underlined, just it appears. Rather, it appears that Tully simply watched the manner in which other subpoenaed parties have been handled in this case, emphasis added. These two arguments refer to the fact that multiple third parties Reed has subpoenaed have either ignored such subpoena, and therefore the court's commands are sought to evade them. Let's go to the next page. Or sought to evade them. Which will likely leave her forced to conduct a dozen or more depositions during the final month of discovery in this case. Here is the factual basis that the judge required them to provide by yesterday at noon. Dexter is in the corner. Look, he's here. You can't see him. He's dark. He's got a dark background. He's there. He's up in the corner, but he's been there for a long time. Sometimes we need the worldwide privacy up in the corner. The worldwide privacy tour, for those of you who watch South Park, it is season 26, episode 2, the worldwide privacy tour of Canadian Prince Harry and Meghan Markle. There they are, curtain twitching out the window. And here they are when they moved in across the street from Kyle and put, we want privacy, we want privacy, we want privacy, because that's what they all want. They all want their privacy. And yet they also are suing Karen Reed for defamation. I know, Rebecca, I saw that earlier. Turtleboy's really going to Block Island with his kids for vacation. I thought it was hilarious. People in the chat this morning were saying, did Melanie send you there? It's a real place. A lot of people didn't know that either. Here we go. And here's their factual basis for all of the things that they said that the judge got butthurt about. 1, on May 20th, 2026, Colin Albert informed Reed that he would be indefinitely unavailable for deposition after June 2nd, 2026, and continued to refuse to produce nearly all documents that Reed sought. 2, on May 20th, 2026, this is all on the same day, Tully, through his counsel, agreed to July 8th for Tully's deposition, which was moved at his counsel's request. On June 1, 2026, Brian Albert served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed his subpoena date. Oh, we know now the deadline is 10 days. You have 10 days to object to the document request in a subpoena. And if you do it after 10 days, it may be waived, but the court has wide discretion. On June 1, 2026, Nicole Albert served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed her subpoena date. On June 1, 2026, Jennifer McCabe served objections to producing documents well after the deadline to object had passed, and the next day claimed to be unavailable for multiple weeks that followed her subpoena date. Same exact paragraph applies to Matthew McCabe. Same exact paragraph applies to Allie McCabe. And it says here about Allie McCabe, on June 1, Allie McCabe served objections to producing documents well after the deadline to object had passed, and the next day stated she was unavailable for her chosen deposition date. However, she later agreed to appear on such date with only 2 days' notice, and then testified that, in fact, she never had concrete plans, that is, reservations, traveling companions, etc., requiring her to be away on the date of her deposition. Oh, interesting. She never had concrete plans. Isn't it so interesting that Allie McCabe, daughter of Jennifer and Matthew, gets thrown to the wolves? And by wolves, I mean defense attorneys, to be given a deposition, to be deposed. And they don't want to, but Allie has to. Did the rest of them? Remember, all of these people represented by Tuxbury's firm and Chris Maddie, they're all represented by the same people. Tuxbury, I think, is a civil litigator. We know that. I mean, not Tuxbury, Maddie. Maddie is the guy who got the big $1 billion verdict, or judgment, I should say, against Alex Jones for, his shenanigans and alleged defamation in the Sandy Hook cases, right? I don't think he's collected a dime, because I don't know if Alex Jones filed bankruptcy or anything, but They let Allie McCabe go in there and be deposed. And then the first question probably was, Ms. McCabe, you tried to adjourn your deposition by saying that you couldn't possibly come in. Did you have a vacation planned? No. Did you have any reservations to be somewhere? No. Were you traveling with anybody, or did you have any invitations or something that you couldn't? No. So she said she couldn't make it to the deposition. And then 2 days before the deposition was supposed to happen, she said, oh, by the way, yes, I can come. I can come. So she did. She gave her deposition. But she really had no plans to be away. So again, Allie McCabe, Matthew McCabe, Jennifer McCabe, Nicole Albert, Brian Albert, and Colin Albert, all represented by the same attorneys. I'm pretty sure Tuxbury and Maddie know the rules about 10 days, about objecting within 10 days. And then on June 5th, 2026, third-party witness Michael Proctor filed his emergency motion for a protective order seeking to continue his deposition scheduled for the next business day, despite having been properly subpoenaed in April of 2026. On June 16th, 2026, Julie Albert failed to appear for her properly subpoenaed and noticed deposition. He just was a no-show. She ghosted. Julie Albert just didn't even show up and didn't have any attorney file anything or send a letter on her behalf. The rules don't apply to these people, they think. They've gotten away with it for decades. I'm talking about Michael Proctor, Sean Goode, Tully, all of them. They've gotten away with things for decades. I think it's come out that Brian Albert has sucker punched a colleague or two in the past. We know that Chris Albert killed a man named Peter Berger in the 90s in a car accident in which he fled the scene. Peter Berger, exchange student, died. Who knows what would have happened if Chris Albert actually stopped and tried to render aid. Chris Albert actually did murder a man. He's the father of Colin, husband of Julie. Ran for town select board, interestingly, after the murder of John O'Keefe. And the Canton Select Board is the boss of the Canton PD, right? I mean, is that not correct? That the Canton Select Board is the boss of the Canton Police Department? Do you see how incestuous this is? Michael Lank has been fixing Albert family business since at least the Lopolato brothers. Was it Chris Albert that was in a bar fight and called Michael Lank to the scene, and Michael Lank filed some false charges against the Lopolato brothers and maybe punched, or he bit a man. He bit one of them. Michael Lank bit one of the Lopolato brothers. They sued the town of Canton, and the town of Canton had to pay a whole lot of money. Michael Lank also was forced to arrest another brother. I think it was Tim Albert. After Tim Albert rear-ended a woman at high speed at a traffic light, fled the scene, and then just like Hansel and Gretel, Michael Lank was able to follow the oil spill from the scene of the crime, which led him to the driveway of 34 Fairview. Unfortunately, in that case, he couldn't really fix it. He kind of had to arrest Tim. I think, was it Tim? Yeah, Lank bit someone. Yeah, how did you not know about the Lopolato brothers? Oh, yeah. 2002. It was Lank, Tim, and Goode? I thought it was, I forget which Albert it was that he went to rescue. Yeah, Lank bit a man. Yeah, oh yeah, we had a good laugh about that. But who was it that rear-ended the woman at the traffic light, and then the oil spill led them to the driveway of 34 Fairview? So he kind of had to arrest I think that was Tim, right? Tim is the brother. Tim is the brother who filled in his in-ground pool. He filled in his in-ground pool for an unknown reason. And many people think that Chloe might be buried there. Has anybody ever dug up the pool? No. No. Nope. So that really wasn't, it didn't involve a lot of investigative skill following the oil spill, but he kind of had no choice. And was that Lank and who was with Lank? Goode? Was it Lank and Goode that did the Tim arrest, and Tim lives across the street from the Canton PD? And Erica just says, they're a pack of wild dogs. Calla lily. Calla lily, my calla lilies have come up in the backyard. They are so beautiful. It's my favorite flower. Also, Taylor Swift's favorite flower, which is one of the reasons that many people did believe that she was getting married this Friday, and she is. And I'll tell you how I know for sure. Number one, all the calla lilies in the tri-state area have sold out. You can't get them. All the flower markets have none. 43,000 calla lilies have been purchased or something like that. And Mariska Hargitay, one of our SVU favorites, the Benson and Stabler and Benson. Olivia Benson is on Broadway right now in a one-woman show called Every Brilliant Thing. Her Broadway show is dark on Friday night. So, of course, she's going to Taylor Swift's wedding. Of course she is. So, sorry for that side quest, but I do love calla lilies. So Julie Albert just failed to appear. And then on June 18th, 2026, third-party witness Tully suddenly served his motion to quash after his counsel had previously accepted service of the subpoena on his behalf and requested that Reed reschedule it, which he did. At no point before June 18th, 2026, did Tully object to the subpoena's request for responsive documents. These events form the factual basis for the arguments referred to above, right? It had nothing to do with the judge. Here's the facts, Judge. Here's what each and every one of these people did. They're not even pointing out here that all of these people, except for Michael Proctor and Tully, all the Haas defendants and Haas children are represented by the same damn attorneys. The judge knows that, I'm sure, but. And that was filed by Damon Seligson. It was served on, everyone yesterday, as the judge ordered. And if we look at page 1, let's go back to page 1 for a second. That'll tell us exactly when it was stamped. By the court. No, that's page 2. But, here it is. It was filed yesterday at 10:24 a.m. Oh, well, I'm sharing the wrong screen with you. Hold on a second. Like, here it is. And I'm looking at the wrong document. Here it is. Filed yesterday at 10:24 a.m. Remember, they had a noon deadline. It was filed. It was not a dig at the judge. It was simply pointing out what all the other Haas defendants and Haas children did. And the judge is butthurt by it. So I guess he was waiting for that before he's going to rule on this Tully's motion to quash. And I'm here for it. I'm here for it. And so are you. I loved when Katharine Hepburn said the calla lilies are in bloom. Yes. Yes. All right. Well, are you ready for it? Are you ready for the papers on the Meredith O'Neill wiretapping charges? It's a felony. And the police department in Leominster District Court, or the Leominster, where's this? Somewhere. Hold on. Holden Police. It's the Holden Police that investigated this. This goes all the way back to December of 2025. Okay. December of 2025. And it has just been filed. It was filed like yesterday. Here's the statement of facts. And you don't need to send me any kind of cease and desist letter. Nan Gallagher, who apparently represents Meredith O'Neill and Jen Altman in some things. I don't even know what, but she's apparently sending out letters that she represents them. This is Meredith, Turtleboy's ex-girlfriend. Here it is, the statement of facts in support of an application for a criminal complaint. The undersigned alleges the following as a full statement of the factual basis for the offenses for which a criminal complaint is sought. This is in the trial court of Massachusetts District Court Department, Leominster District Court, 25 School Street in Leominster, Mass. Get the red pen ready. Okay. On December 1st of 2025, this officer was dispatched to the lobby of the Holden Police Station to speak with Aidan Kearney regarding illegal wiretapping. On my arrival, I met and spoke with Kearney, who stated the following facts and circumstances. 2. Kearney stated that he was in a 1.5-year relationship with MEREDITH O'NEIll, and they broke up in July of this year. Kearney stated that they stopped talking, but then started talking again on or around September 1st of this year. And then when they say this year, that goes back to 2025. Kearney stated that he recently learned that at least 4 cell phone conversations on or around September 1st of this year between himself and O'Neill were posted on social media by O'Neill. I don't remember what these conversations were about. I don't remember hearing them, but I'm sure many of the chat remember. Kearney stated that he did not know or consent to any of their cell phone conversations being recorded. Kearney stated that during the conversations, O'Neill was trying to get Kearney to admit to acts of infidelity while unknowingly being recorded. Kearney stated that his calls were recorded while he was at his residence here in Holden, Mass. Kearney played the conversations to this officer and was advised to send the conversations to this officer for this case. Kearney stated that O'Neill was going to lie and say that she was in Rhode Island when she recorded the phone conversations, but that it was not true, as he knows she was at her residence in Boston, Mass. Oh my God, are you kidding me? Hold on a second. Oh my God. No, please. Okay. On December 2nd, 2025, this officer called and spoke with MEREDITH O'NEIll. I advised O'Neill that I was calling from a recorded line. I then asked O'Neill about recording phone calls with Kearney. O'Neill stated that she did record too. Okay, and this is the officer here who filled out this report. His name is Todd Ventres, Ventres, law enforcement officer. He signed this on December 4th of 2025. O'Neill stated that she did record 2 phone calls. Got to bring up the next page. Hold, please. Two phone calls between her and Kearney, but that she was at a friend's house in Rhode Island when she made the calls. That's exactly what he said she would say, right? I don't know. O'Neill stated that Kearney would know if the calls were recorded because it says when you click the record function on an iPhone. O'Neill said she did post the recorded calls that she recorded while in Rhode Island on her social media X page. O'Neill said that she hasn't spoken to Kearney for a while now and that she's blocked him. O'Neill stated that Kearney is blaming her for something, so he has been having his followers constantly harass her by contacting her employer to try and get her fired. Remember, this goes back to December of 2025. O'Neill said that she has DCF coming to her house to check the welfare of her child due to some followers of Kearney making false allegations to DCF. That's disgusting. That's horrible. That shouldn't happen. I don't know if it's true or not, but nobody should ever, ever, ever do that. I advised O'Neill that I would be sending this case to Leominster District Court to request a two-party hearing and to bring any evidence she has with her. On December 2nd of 2025, Kearney emailed this officer with 5 audio recordings that he states were illegally recorded without his knowledge that were posted on O'Neill's Twitter/X social media account. So there are 5 recordings. Kearney also sent attachments with his cell phone statements showing that the phone calls to him were made to him from Hyde Park, Massachusetts, which is where he states that O'Neill lives. Kearney states that O'Brien, well, it's really O'Neill, not O'Brien. Kearney states that O'Neill recorded the calls using the recording app on an iPhone. And when you use that app, it gives you the exact street you are on now and the town name, which his cell phone statement said the calls came from Hyde Park, Massachusetts. Kearney further stated that you can go in and edit the recording location, which is what O'Neill did, to say that the calls she made were from Watch Hill, Rhode Island. Oh, that's so ironic. Isn't that where Taylor Swift's house is in Rhode Island? Where she had Taylor Swift's house, her friend Taylor Swift in her fantasies. She's a Swiftie. Which is what O'Neill did to say that the calls were made from Watch Hill, Rhode Island, although she was in Massachusetts. Kearney stated that he tested his theory and he sent a video showing what he stated above. Signed, Officer Todd Fentress. And then page 3. Of this criminal complaint states the following. It's Taylor Swift's location. Smart, but not smart enough. At this time, this officer is requesting a 2-party hearing regarding illegal recording / wiretapping by MEREDITH O'NEILL as alleged by Aidan Kearney. XOXO, December 4th, 2025. This was filed. They did have a 2-party hearing, right? I think they did at some, I can't follow everything that everybody does, but I think at some point there was a hearing on these wiretapping charges. And I think that just yesterday, that is when these charges were filed with the court, and she's going to have to show up to court for an arraignment on this. Hold on for 1 second. So here it is. It was just filed yesterday, apparently. We like receipts, so I'm getting you the receipts. There you go. Criminal charges were filed yesterday, 6/29/26, for unlawful wiretapping in violation of 272 Section 99 C1. This is Leominster. Date of the offense, 12/2/2025 in Holden, Massachusetts. She will be arraigned July 30th, 2026 at 8:30 a.m. in Leominster District Court. So I'm not sure what happened at that hearing. I'm sure Aidan probably talked about it on his show, or maybe he didn't. I'm not sure. But the criminal complaint has issued. She will be arraigned. And this all just happened yesterday. She will be arraigned on July 30th, 8:30 a.m. District Court usually doesn't have cameras or anything in it, or even Zoom capability, but I guess we'll see. You can always order the FDR recording. And there it is. Could she go to jail? Let's see. Let's look up the penalties for illegal wiretapping. 272, section 99C1. For those of you who would like to be entered in the drawing that we're going to do for the trucker hat, I went to Cancun with attorney Melanie Little trucker hat. All you got to do is comment in the chat. If you've already been commenting, I have already been collecting your comments. Don't comment too many times. It may disqualify you. So if you've been commenting since I hit go on this button, there's already 112 of you entered. So if you would like to enter this giveaway, all you got to do is comment in the chat. No specific thing. Just make any comment. Say something nice. Say something nice. Compliment somebody. Say something nice. If you win, and only if you win, you need to be smart enough to find my email address in the show notes below. You need to send me today only. This is going to expire today. Put trucker hat winner in your subject line and send me your name and address and phone number and what color hat you want. Do not send me an email if you do not win. Okay. I don't need 400 emails. I don't want your address unless you win. Okay. Say something nice. All right. We're up to 267. Happy July 4th weekend, everybody. It's not the weekend yet. Well, it's only Tuesday. Don't rush it. Let's go back to the chat. No, I'm not talking to you. That was that robot in the corner that's always listening. In camera B6, thanks for becoming a member. Thank you. He's like, I'm here if you need me. It's getting creepy. It's getting creepy. The witty banter with that machine over there, whose name begins with A. Mine's a man. And he's really said some weird things lately. It's weird. We Are the Lucky One says, I love your coverage. You're my number one. Thank you. I love you with all of my heart. Where can we buy merchandise? Thank you for asking, Brandy. We just looked at some of the merch. It's 20% off. The link is in the show notes right underneath the video. It says there's a fire emoji and then it says merch. Your dad's favorite mom said, I wonder if Proctor's lawyers told the judge the order was violated because info about Proctor having a panic attack during the deposition was reported. No, I don't think so. It only has to do with the impounded materials contained in paper number 112. That's it. That's all it has to do with. Tomorrow's going to be the 3 o'clock hearing. I'm here for every minute of it. And Boozy Beauty's going to go to court. Thank you, Susan, for gifting 5 memberships. You're a sweet pea. Samantha, thanks for your 10, says it's infuriating that no one's ever been held responsible for anything, but they always talk about how horrible other people, races are for breaking the laws. They think they're above the law. Yes, they do. Yes, they absolutely do. If you'd like to be entered in the giveaway for a trucker cap that says, I went to Cancun with attorney Melanie Little, just write something nice in the chat and you will be entered. No purchase necessary. Just giving it away. Because I'm in a giving mood and you guys are awesome. Once again, here's what the hat looks like. And it comes in several different colors. I mean, how cute is that? Here's the logo. I went to Cancun with attorney Melanie Little, established in 2024. I've got the bracelet on. You're right, Samantha. You're right. And thank you for your 10. And Tanya says Karen's response to the judge's request for factual basis has been posted to the docket. Thank you. We just read it. Thank you, Dr. Russell's gas per your Cash App says thank you for spending so much time with us. Steve, thank you very much for your Venmo. Says a great live today. Living the dream in the White Mountains while watching you on my day off. Oh, I'm so happy I can keep you company on your day off, Steve. Thank you for your Venmo. Appreciate it. Marie, it's Marie. I love your show and appreciate you. I love you and appreciate you too, Marie. Thank you for your Venmo. All right. Let's see. Thank you, Tanya. We just read it. We just went over it. Rewind. We might have crossed. Sunflower Day says, you're my favorite channel. I love you with all of my heart. Thank you. Thank you for being with me for 24 months. Remember today's the affirmation fell. If anybody remembers the affirmation, put it in the chat. Kitty just says the. US Lily says, I purchased the travel pillow. It's amazing. Thank you. Oh, the one that's on my Amazon recommendation list. I love it too. My daughter stole it from me on our flight from London, so she got to sleep very nicely on the 7-hour flight. Oh, thank you, Kyle. Thank you, Kyle. So motions to compel have hit the docket today on Nicole and Brian Albert, Jennifer Matt McCabe, Allie McCabe, and Brian Higgins. So those motions to compel were filed. I'm sure they're all the same, and they just say we want them to show up. They're not showing up. They're refusing to show up. And I got the response to the court, and we did cover that. I don't think we need to cover the motions to compel because I think they're all the same. Okay. Thank you. Yeah, I love that travel pillow too. It's awesome. I have it in green because I really wanted the yellow one and it was sold out. The virtual juror said I emailed you the PDF. Thank you. But I already got it. I mean, I did what I did. Case Notes Unfiltered. That is Kelsey Fitzsimmons' channel. Let me just go there for a moment to show you. So if you want to watch, Kelsey Fitzsimmons is doing a podcast, a YouTube presentation with Courtney the paralegal. And I think that is there video dropping today because there's nothing scheduled on this channel. I thought they were going to release the video today. I'm going to show you what the channel looks like so you can go over and subscribe to it. It's called Case Notes Unfiltered. It's already got 1,140 subscribers. And I thought they were going to drop a video today, but it doesn't seem to be up yet. Like there's no notification or anything. It just says this channel doesn't have any content. So I don't know, but that's Kelsey Fitzsimmons' channel. So I thought it was dropping today, but maybe I'm wrong. Maybe they delayed it. I have no idea. Just have no idea. Thank you for reminding me of that. And Casey says merch idea, but wait, there's more. And Melanie, little cupcake pins. Oh, we do have pins in the merch shop. And I was going to do this for like when cupcakes go to court because I thought this was a really great idea. So you can buy a pack of 5. Let's go back to the merch tab for one moment. And it's under the accessories tab. So there's also stickers and stuff, but maybe it's under other. A little keychain, little doggy bandana. But wait, where is it? Buttons. Here it is. You can buy a pack of 5. Pack of 5. $7.99. I went to Cancun with attorney Melanie Little. And then if you buy 5 of these and you meet other cupcakes in court, you could all wear these buttons. And then you can identify each other out in the wild. If you're in the wild in court and you're a court watcher and you have this button on, you'll see each other and you'll be like, oh, you're a cupcake too? Thank you, Sheep Teed, for your 10. Thank you. Motion to compel the McAlberts on the docket. Yep, saw it. I just don't have time to cover it right now because I need to get outside and get some sun. Paula, thank you for gifting 5 memberships. You're amazing. Cherie would love some merch to Australia. Yeah, that's the thing. This is not like Amazon. So if you win and you're in Australia, it's going to take a while to get there. And if you win and you're in somewhere like Switzerland, you might have to pay like some sort of duty or something when it comes over. Just be cognizant of that. I don't know how that whole thing works, but I did send somebody some merch and I think she had to pay like a VIG when she picked it up. I don't know how it works. All right. We got 630 people so far who have put comments in the chats to win. All right. Here's what we're going to do. Thank you. I stand with Mel. Any volunteers to be Proctor's personal life coach when all this is over? I'm thinking maybe taking him to the Wailing Wall and getting him one of those wise old gurus. A guru would be great. Thanks for your time, girl. Tortoise Interference says, without my address, how will you know where to pick up my kids to take them to Brazil for me and claim your acreage? I know even 5 acres of land won't do it. Can't win. Thanks for being here for 7 months. Love spending my day with attorney Melanie and fellow cupcakes. All right, we're doing it. We're doing it. Ready? Here goes the first drawing. And who will the winner be of the trucker cap? Do 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 do. Ah, there it is. DCJ Peppers. DCJ Peppers, you are the winner of a trucker cap. You have to email me, fanbase@mlittlelaw.com. Put winner trucker cap with your username in the subject line. Send me your name, address, and phone number and the color hat that you want. Remember the color choices. Or go back and look at them. CU 1980 said Lord Peter Wednesday's go Buffs. We have a buff emoji. There's a buff emoji in the chat. I and 3 of my children are all buffs. I'm a buff. We're a buff family. Sco Buffs. I love Boulder. Before the internet, I would dream of Boulder every night since I left. In fact, I love Boulder so much that I decided to go to law school because I thought, what can I do to stay in Boulder and not have to go get a job? Oh, I know. I'll go to law school. And so I stayed in Boulder for 3 more years and I went to law school. And here I am on YouTube. All right. You know what? I'm feeling generous. Let's do it again. We're drawing again. We got to win at number 2. We're going to get moved to number 2. Winner number 2, another trucker cap is going to go to Cheryl Kelleher. Oh, Cheryl, are you related to any of the Kellehers? Cheryl Kelleher, email me, fanbase@mlittlelaw.com with the instructions I previously provided. Color of hat, name, address, username, and phone number. I don't know why they need all that information, but they do. All right, should we do more? Because we got to do everything in 3, like 3, Jenny 3 times, you know, Jenny 3 times. I hit him, I hit him, I hit him. I hit him, I hit him, I hit him. Everything is 3 with Jenny. We're going to do it 3 times because 3 is the magic number. 3 is also the magic number. If you already won, you will be excluded. But if you have chatted, you are still entered. Let's see how many entries we have right now. There are, there's over 6,000 people here. Really? There's only 692. Your odds are still good. The odds are forever in your favor. All you need to do is put any comment in the chat. A lot of people are afraid to chat. They're afraid that the MSP or CanPD is going to find out who they are. 3 is the magic. You know, 3 is the magic number. 3 is the magic number. All right, we're going to give this one more go. We're going to give it one more go for the 3rd and final trucker hat. And I love you guys with all of my heart. If I don't see you soon, I'm going to die. But I'm going to see you soon because tomorrow is the 3 p.m. conference on Karen Reed. And we're going to be on standby to see if we can get it. And who knows what other papers will drop. You never know. You never know what's going to happen. Here we go. 3rd and final drawing for another trucker cap. Here we go. Do 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 do. Tammy Tebow, you're the winner. Yay, winner, chicken dinner. Now here's the thing. I know that the sun goes behind the tree at 4:25, so I'm going to get outside and get a little vitamin D because I need it. I'm feeling a little pale right now. I love you guys so much. Thank you to the moderators. Congratulations to the 3 winners today. I could never do this without my moderators. The moderators are doing the Lord's work. They're amazing. They're amazing. My moderators are all people that I trust implicitly because a moderator can screw your channel. It is true. It is true. And so you need to be very careful who you trust. And so that's just, pearls of wisdom from me. I love you guys with all my heart. If I don't see you soon, I'm going to die. I'm going to see you soon. So you have to make sure you subscribe. All your notifications are set. YouTube has been unsubscribing people, hiding people, blocking people. If you're blocked and I can verify that you're actually not a dick or a troll, you got to email me with the link to your channel. It has to be a link. It can't be a username. It can't be the link to your channel. I don't have to go back and forth with people a million times to try and unblock you if it happened by accident. Aloha, Jen Casper. I can't wait to be back in Oahu on Oahu, I should say, very, very soon. Well, within the next 60 days or so. I love you guys so much. I'll see you soon. Comment respectfully. Be kind to each other. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. And do all the things that YouTube likes. You know what they are. Love you guys. Peace. Peace. Let's let Toy play us out with the Cupcake Yacht Club song. Because, when people troll me, my viewers make videos and I make merch. So thank you to Toy. Toy Box. Is it Toy Box Media? Hold on. Toy Box Media, TOI Box Media for the SS Cupcake song, and just enjoy all of the Easter eggs in this really cool video. Love you guys.
Ahoy! Welcome to the SS Cupcake Yacht Club. All aboard! SS Cupcake, steady vibes on love already. Floating on this don't see so sweet. Smooth and clean, I don't know what I mean. We're cruising. Gotta try. Yeah, yeah, oh yeah. Say it loud, make it chatty, yeah, 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 oh yeah. Galley crew, we I love you. Today's Satan, oh no, yeah. No, 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 no. Spot for you, Black Island. Already had a speedy ride for you on the SS ship of fools. Bye-bye. Yada, 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 yada.